May please, Lord.
Yes.
My Lord, yesterday my colleague they filed one writ petition at 4, but the matter couldn't be listed today, maybe because of the late filing. So I may be allowed to move at 2. Much.
Mr. Lordship, I'd like to mention item number 10.
Then,
Yes.
Mr. Joe,
My Lord.
is it a writ petition?
Yes, at 2.
Can you not mention it in the court number 1?
My Lord, there is hearing item, so I thought it will continue.
Is it?
And yes, very much. There are hearing items.
So is it permissible?
But, my Lord, to the best of my knowledge, there is no bar. There is no such rule that we cannot mention before any court. Yes, my lord, there is no bar. Yes, ma'am. Add two on my.
Lordship, item 10.
Yes.
Lordship, here the state will have filed an SLP before the Supreme Court. So Lordship, this morning I talked to the Advocate General and he says that the matter is the state will have filed 6 SLP. So they are going to club everything and going to be listed. So I feel that 6 weeks time may be granted to Lordship.
Also, my objection, SLB still connected with the present case, no appeal file. So the subject matter, the issue facts may be different in the SLB pending before the Supreme Court. No appeal file against the order in this condition.
No, no, SLP
appeal.
Lordship, in this case, there was no appeal filed, but in a similar case, where similar direction was given for minimum scale of pay, Lordship. That matter was referred before the Supreme Court. So this contempt also will be subject to the outcome of the SLP.
Facts may be different. That should be taken up independent lawsuit. Independent lawsuit, separate.
You file an affidavit in that case. It's maybe a ground for impossibility of compliance.
Lordship.
But just filing a appeal or review
Yes, Lordship.
should not be barred.
Yes.
On that ground, it cannot be. We'll ask, let her file whatever.
Lordship, I found my affidavit, your Lordship. So Lordship, then in that case, 6 weeks.
Not
6 weeks, your Lordship. Don't make
Now,
it,
within these 3 weeks, we'll give you 3 weeks. Whatever is there, you
Lordship.
take the steps. Heard Mr. What is learned counsel by the petitioner? Item 10, MS. We Shokri learned counsel appearing on behalf of Alice Contemptor, praised for and granted 3 weeks time to file affidavit in opposition.
Much obliged.
List after 3 weeks.
May I please, Lordship?
Yes,
I'd like to mention item number 21, my lord.
21.
Yes, my lord.
Yes.
Here are instructions to appear for the respondent number 3, that is the vehicle owner. So I'm yet to file my Bakalan number. I'll be filing my Bakalan number within a day or 2. So I may be given 2 weeks time to file my Bakalan number and necessary objection.
Why you require 2 weeks time to file Wakalatnama?
So I'll be filing within a 2 or 3.
Okay. Mr.
And no comment, my lord.
So in learned counsel submits that he has an instruction to appear on behalf of respondent number
3.
3. For which he requests some time to file the or as well as counter affidavit
Yes, my lord.
and phrase 4 listing the matter after 3 weeks.
3 weeks. Lordship, I'm appealing for the appeal.
Appellant.
Yes, sir.
Mr. So learned counsel for the petition. Learned counsel for the appellant appears present.
Your Lordship, for respondent 1 and 2.
MS so you just write Mr. So learned counsel appellant and MS so learned counsel for respondent number
1 and 2.
1 and 2 present. List after 2 weeks.
Much obliged.
2 weeks or 3 weeks?
My lord, 3 weeks. My lord.
3 weeks. Yes,
My lord, I have a similar prayer for item number 23 also, my lord.
23.
Here I have instructions to, I'll be appealing for the condemners here.
All.
Yes, for all the condemners. So I need.
Any objection?
No objection.
I may give 3 weeks time to file this affidavit.
Mr. So learned counsel for the learned counsel submits that he has an instruction to appear on behalf of Alice Containers, for which he requests sometime. Mr. And phrase 4. Not Mr. And phrase 4 listing the matter after 3 weeks. MS so learned counsel for the petitioner present.
Much obliged.
Yeah, please, my lord. Lordship, I'd like to mention item number 14, Lordship.
14.
Lordship.
Yes.
Lordship, can you grant me 3 weeks time, Lordship? 3 weeks.
Limavo, objection.
No, Lordship, if you are going to comply, then I will not object. If the-
Huh?
This is a contempt matter. So if you are seeking the time for compliance, the order passed by this.
You are seeking for compliance.
Lordship, department is facing difficulties because of the orders in conflict with the office memorandum. So,
See, orders
so
of
whether,
the court cannot be conflict.
of course,
Either appeal or they have to comply.
It best, at the highest, it may be, it was not brought to the notice of the court.
Lordship,
And even if there is a conflict,
Yeah.
after consideration according to you,
Lordship,
which will prevail,
Lordship.
your
so-
office memorandum or the court's order?
No, Lordship, that is why Lordship, is under consideration whether the appeal should go or, we have to comply. So sometime we will require.
No, you cannot have that. Either you will comply or you will not. It's not that. Either you have to file an appeal if
Yes.
you cannot comply or whatever, according to you, if it is not correct.
Lordship,
You just cannot have a choice.
Lordship,
Choice is only to file an appeal before the appellate court.
Lordship,
That's all.
Lordship.
That will grant you 1 week time. You decide.
Lordship, 3 weeks time, Lordship. So the,
What is to be complied? What is the direction?
Lordship, the petitioner, she was a work trust employee. As per the scheme framed by the state government, a work trust employee can be considered after he rendered 30 years of continuous service. Petitioner was released from service short of 3 months to complete the 30 years. So court has, the petitioner was
With highest respect for the order. After 3 weeks. On the prayer of Mr. B.G. Mobi, learned counsel for the alleged contempt. This matter after 3 weeks. Mr. Lima Wapang, learned counsel for the petitioner project.
obliged.
Lordship.
By your submission, I am not convinced.
Lordship, item number 31, Lordship, on behalf of MS Mary. And grant 3 weeks time,
31.
Lordship.
Who is called petitioner? Subhamwati. Huh?
And for the petitioner, my lord.
So any objection?
Adjournment has been sought, lordship, for so many times, your lordship.
What is the matter?
It is simple only, your lordship. The petitioner is seeking for regularization of office pass service as per office memorandum 2004.
For me, it may be very simple for the concern, but for this court is very difficult because law may not, law doesn't,
With effect, my lord, there is no dispute also.
law doesn't support you. There may not be dispute, but law, there's a dispute in the law which goes against you.
Yes, your lordship, I understand, your lordship, but the petitioner has retired since 2020, my lord.
That is the problem.
And
That is the problem.
yes,
Why you have filed this matter after the retirement?
no, your lordship, even before the retirement, he filed for regularization of the service. And this.
Same.
Yes,
It was filed
yes,
before the retirement.
yes, before the retirement, lordship.
After
If
retirement,
your
once you
lordship-
enter the retirement life, it's
My
a,
lord, this is the second litigation, your.
it's a nice evening of your life. Enjoy the evening of life. Don't go for all
It is
this.
the second litigation, your lordship. In the first litigation, your lordship, this honorable court has directed for regularization of the service, your lordship, and the contempt petition is still in pending disposal, your lordship.
What does the word retirement implies?
Your lordship, as soon as,
You have nothing to do now. Enjoy the life, the evening of your life.
your lordship, the petitioner is now in a very distressful situation, your lordship.
So after retirement, why should be distressed?
When the petitioner is not.
You enjoy
in
the
retirement,
retirement
your
life.
lordship,
Anyway, your colleague is not available.
Lordship,
Your lordship,
yes, actually she's around, but she's attending court 1, Lordship.
your lordship, let it be,
She's objecting, we'll see.
if it may be heard, your lordship, after all the
If it is heard, it may go against you.
lordship, and this way, lordship.
We'll see.
Okay, Lordship.
If she's around, if she has some difficulty, we'll accommodate. All right. She is having difficulty today.
Most probably, actually, since I don't have enough instruction to appear, but I think I'm told that there's a contempt pending and the petitioner in the contempt is likely to get some relief and even the petitioner is likely to get benefited out of that, something like that. So I think it is also to her benefit that.
We'll record it. We'll record it or it don't matter.
But that is.
Mr. BJB.
Yeah, I'm going to.
Okay, I'm going to let it, State Council.
Yes.
While mentioning this matter, submits that in view of the order of this court in the other proceedings, there is a likelihood of granting relief to the petitioner. Therefore, press will listing the matter after 3 weeks. Whereas MS so Learned Council for the petitioner present list after 3 weeks.
Obliged, Madam.
You don't have to do anything.
Representative,
Yes.
I have just to mention item number 25, Your Lordship.
25.
Well, 25 and 26. Your Lordship, this court is electing to give Your Lordship.
Yes.
However, this may also Your Lordship, I get I seek for clarification and they say that like it's 2006, so they could not be able to trace that record and it might be in the lower court also. So I just told them that okay, that is the case clarified. So at least we can seek a direction from this court to bring the lower court to bring the records. So Your Lordship, thanks to Your Lordship, so that at least if they give me a confirmation, Your Lordship, there is no only court will give a direction for going of records from the lower court, Your Lordship.
2016 matter.
Yes, Your Lordship. That's why Your Lordship, I'm also making an endeavor, Your Lordship. But since it's 2006, they could not able to locate the records. They're stating that we have gone to the
I
lower
can
court.
file the affidavit.
Here, Your Lordship. Yes, Your Lordship. If it is really filed,
The affidavit
Your Lordship, that is the case, if tomorrow can come and trust Your Lordship.
day after tomorrow.
Yes, Your Lordship.
On the prayer of MS Libika Learned the State Council list this matter. And the prayer not being objected to by Learned Council for the petitioner list this matter on
Thursday, Your Lordship, day after tomorrow.
21st, 21/9/2022.
Yes, Your Lordship.
No further adjournment will
Yes,
be
sir.
granted.
Yes, Your Lordship.
We'll dispose it of
Yes, Your Lordship.
therefore.
Obliged.
Your Lordship, I also beg to mention item number 6.
Decision 25 and 26.
That is 25 and 26, Your
Ah.
Lordship. And now, Your Lordship, item number 6, Your Lordship.
Ah.
Need to receive instruction on the newly invented, this, Your Lordship.
Same,
Yes, Your Lordship.
6th time.
Yes, Your
Six
Lordship.
times.
Yes, Your
You are
Lordship.
seeking adjournment.
This is not the 6th. Your Lordship, I think this is the second time, Your Lordship.
Second time.
Hmm.
Okay.
Lordship, I do not know what instruction will come from the newly implemented deputy commissioner.
Why you have bleeded him then in that case?
No, Lordship, on the instruction, on the direction of this honorable court.
So according to you, this court was wrong.
Not
Directly
necessarily,
will-
Lordship, but what
No,
new
answer. Bleeded, she has to get the, is it on the facts of the matter or is it on the law?
On the facts, on the facts,
So
Your
on
Lordship.
the law, you did instruction.
No, Your Lordship, on the facts.
Lordship.
6 weeks,
No, 3 weeks, Your Lordship.
3 weeks.
Ah.
And Mr. Jeswa Sekil and Council for the Mr. MS Libika Learned Council to the petitioner fresh for listing the matter after 3 weeks so as to enable her to obtain instruction with regard to the in respect of newly implemented respondent number.
Respondent number 5, Your Lordship.
5. Whereas the law list this matter after 3 weeks.
Much.
Instruction.
Yes.
Lordship, I think you mentioned, I think, 12, Lordship.
Item 2.
12.
Yes.
12.
12. Okay.
And for the petitioner, Lordship,
Yes.
my senior is out of station, so Lordship, my
Are you session or under medical treatment?
treatment in Dipugad, Lordship. Of station. So Lordship, may kindly grant in 2 weeks' time, Lordship.
On the prayer of Mr. Posiko for the Learned Council, appearing on behalf of Mr. P.D. for Learned Council for the petitioner. And not been objected to by the Learned Council, Mr. Jeswa Sekil Learned Council for the respondent
Yes, Lordship.
and K. Angami.
And for the respondent number 1 and 2.
Respondent number 1 and 2 for K. Angami so and so. List this matter After 3 weeks,
2 weeks, Lordship.
weeks,
Lordship. May I please, your Lordship.
yes.
My Lord, I'd like to mention item number 11. Here, Lordship. My Lord, may kindly grant me 2 weeks' time. I have received a document that I have sought for from the District Court Mukokchung.
Item 11,
11, Lordship. The affidavit is under
the
preparation.
original insurance.
Lordship, I'm for the respondent here. The
Yes.
respondent number 3.
Insurance.
Yes, Lordship.
Okay.
The respondent number 3, Lordship, is the vehicle owner, not the insurance.
No. This matter is in original insurance.
Yes, Lordship.
Item 11.
My Lord,
You are for
I'm for the respondent number 3, the vehicle owner.
Mr. Jaswasaki, learned counsel for the petitioner. Learned counsel for the respondent number 3. Praise for and granted 3 weeks time.
Your lordship, I'm for respondent 1 and 2.
And
Let
so
us-
and so,
And we have already filed our objection.
learned counsel for respondent number 1 and 2. Present.
I have appeal for appellate.
Mr. So and so appears on behalf of petitioner. Appellant, sorry. Applicant, appellant. List this matter on after 3 weeks. 2 weeks.
May I please, your lordship? Your lordship, I beg to mention item number 13.
Yes,
Here, your lordship, I'm for respondent number 2, and we will be filing our affidavit in the course of the day. So if your lordship may kindly list the matter after a week.
so and so learned counsel appearing on behalf of respondent number 2.
Yes, your lordship.
Praise for and granted 2 weeks time to file affidavit in opposition. Mr. So and so learned counsel petition present. So and so learned counsel and K. Angami for PP. K. Angami learned PPs present.
Much obliged.
May I please, your lordship?
Yes,
Lordship, I beg to mention hearing item 37 to 39. Since the leading counsel for both the parties are out of session, I pray that this matter
30.
37 to 39.
What is this matter?
This is a criminal petition they have filed to suspend, to quench the criminal proceeding
Okay, you are for,
for the respondents.
I may so and so learned counsel for the respondent, praise for and granted 3 weeks time
No, lordship, let it come out on Monday.
after 2 weeks.
So
You are for petitioner.
Lordship, I have instruction to appear on them, parking. Also for the.
Mr. So and so learned counsel for the petitioner present. So after 2 weeks,
Lots of them.
Yeah, please, your honor.
yes,
I would like to mention item number 29 and 30. I'm
29.
applying for claimant respondent in my seniors in this course. As such, matter may be listed after a week.
you are for,
Claimant respondent.
okay. If you
I'm
are,
for appellant.
Hmm.
I'm for appellant, Lordship.
Mr. So and so learned counsel for the claimant respondent. Praise for and granted 2 weeks time.
After a week. After
2
1
weeks.
week.
Mr. Poseka Pote, learned counsel for the appellant present. After 2 weeks,
Lordship. Yeah, please, Lordship.
yes,
Lordship, I beg to mention item 33, 34, 35, and 36. Lordship, here I'm led by Mr. Tang Chuba.
32 to 36.
33 to 36.
Okay,
Lordship, the leading counsel is out of station. So Lordship may kindly.
nobody appears for respondent.
Lordship, as of now, Lordship,
No, it's on here.
we have taken notice by way of registered AD
It's
as
in-
well as by,
It's hearing
yes, as well as by application.
whether.
Lordship, we have taken.
No, whether this is good job or not. You find out.
We have taken, Lordship, and we have taken by way of substitute notice also. Publication in the paper has been made.
You have
and
found
this-
the affidavit also.
Yes, Lordship, and this order has This one court has passed orders that the service company responses are linked to the company.
On the prayer of Mr. Posikapote, learned counsel to the appellant, list this matter after 3 weeks.
2 weeks, Lordship. Bless my lord. Lordship, item number 3, Lordship. Lordship, the council is from Gauhati. Lordship, the matter came up 2 weeks, Lordship. There's some difficulties.
On the prayer of Mr. Posikapote, learned counsel to the petitioner, list this matter after 3 weeks.
Lordship, this is the interim, Lordship. Continue.
Interim order passed, earlier shall continue.
Bless my lord.
May it please, my lord. Lordship, item number 7,
Yes,
the affidavit opposition is ready, Lordship, and we are awaiting the respondent for his signature. He'll be coming on Saturday. So
this is second time you are seeking.
let the matter be listed for hearing in usual course. In the meantime, my lord, we will file our affidavit in opposition. And let him file the affidavit in opposition.
We'll see.
Yes, we'll see.
You first you file.
Lordship.
Are you sure that it is better to be admitted?
No, this is the final chance. As for the last occasion, she has one final chance.
MS,
I
so
know.
then
A very complicated case.
respondent number,
4.
respondent number 4. Submits that she may be granted 2 weeks time to file affidavit in the position. List of. They are not being objected to by land council to the petitioner. Come on. MS. The Jimobi is granted 2 weeks time to file her counter affidavit. List after 2 weeks.
Lordship, obliged. Well, I beg to mention item number 2 of the petition.
Yes,
I pray that this I may be given 1 week's time. I need to obtain some instructions.
you are for?
I'm for the petition.
What of this
Uh,
was
Yes.
regarding non-payment.
No payment of yours. I've been informed there's a similar case.
Huh?
There's a similar case which was disposed of by this honorable court regarding pertaining to the same issues. So I need to obtain a copy of that order so that I can assist this honorable court with that.
Objection, no. This is something like there was a scheme,
Yes, that was proper.
work order was issued,
Yes,
huh?
yes, work was completed.
And then you have executed the work.
Yes.
In the meantime, the central government has stopped discontinued the project.
Yes.
So state has made its own payment, I mean the own share,
Yes.
isn't it? 20%.
Yes, the state is saying that since the union has stopped the funding, it is the liability of the ministry to clear the liabilities.
What is the construction? What is the work?
Construction of approach road.
Huh?
Construction of approach road.
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 Yes.
You will have to pay. Either the state or the central, which is in between you.
Lordship,
Why you should suffer?
my colleague, Mr. M. Angabi is in the case. He's ready for the case if necessary, Lord.
So you will make the payment.
No,
It's on the
I'm mentioning on behalf of my
Okay,
colleague.
okay. Mr. So-and-so learned counsel for the petitioner submits that. He may be granted 2 weeks time.
1 week, just 1 week.
1 week time to obtain certain insertion. Mr. And Mr. So-and-so present. You have filed your affidavit.
Yes, I.
What is your stand?
Before the work order was issued, the project was already dropped.
Okay.
Only after the project was dropped, then the state government, they have issued the work order.
It will heavy on you. You have to pay the 80% also. Isn't it? Tell Angami, the K Angami. Angami, K Angami.
And Angami.
Lordship, I'm K. Angami.
N. Angami. Are you brothers?
No.
This after I will.
Lordship, I also beg to mention item number 24.
Yes.
In Lordship, in this case, on the next occasion, I was directed to furnish the correct address of respondent number 1.
Yes.
So I have got the new address. So I will find my affidavit within a week. So I will give it a within to furnish the new correct address.
On the prayer of Mr. Yangarbati, Lanet CGC. List this matter after 2 weeks. Yes,
Your worship, I'd like to mention item number 4 and 5 now.
4 and 5.
Yes, worship. Your worship, a week's time may be granted to file,
Therefore,
for the appellants, your worship.
what do you want to find?
An IU for stay of the, order, your worship, impugn order.
Mr. Jetkundu,
Yes, your worship.
learned counsel for the appellate. Praise for and granted 2 weeks time.
A week's time. Your worship.
Which time, please? Which time? This. Mr. So and so, so and so. You are for a respondent,
Lordship, I'm for a claimant respondent,
respondent number
1.
1 and 4
4 in both cases.
present. Huh?
Much obliged.
Right.
My pleasure, Lordship.
Yes,
Lordship, I'd like to mention item number 8. Here, there was an error in my pins and I forwarded make the necessary correction. And my
I
application.
think number 8.
Yes, Lord.
Do?
Here, there was an error in my pins. And then I forwarded made the necessary correction and then the application already. However, the E is yet to forward it to the PNR department. So that will be done
We'll say,
in 3 weeks.
Mr. Himb, Arsimi, learned counsel for the petitioner. Praise for and granted 2 weeks time to take appropriate steps. MS Libika. Correspondent appears, present.
Please, your Lordship.
Yes,
Lordship, I beg to mention item number 27. Lordship, here on 12/9/2023, we were instructed by this honorable court to get the status of the respondent plaintiff as to whether the respondent plaintiff is still alive. So this honorable court granted us 1 week's time. However, your Lordship, till date, we have not received any instruction from the railway authorities. So kindly when us another 1 week's time.
this week you find out and next week will dispose of this 2017 matter.
Lordship.
On the prayer of Mr.
No, sir.
You are not here. On behalf
On
of
behalf of
Mr. So-and-so, on the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. This Nungtung Sila, learned counsel for the appellate. List this matter after a week, so as to enable it to furnish the, so as to enable him to take appropriate steps as directed by this court. MS so-and-so, Ms. Okri Learned Additional Advocate General present.
Lordship.
Lordship, I please. Lordship, I beg to mention item number 28 on behalf of the council for the appellant.
Hmm.
The Lordship can list this matter after 2 weeks.
28,
Yes, your Lordship.
criminal revision.
Yes.
On the prayer of MS so-and-so, learned counsel appearing on behalf of
The council for the appellant.
Mr. Santiagna,
Yes, your Lord.
learned counsel for the appellant. Petitioner. List this matter after 2 weeks.
Yes, your Lord.
Mr.
Kiangami, Lordship.
K. Angami. Before that, before list, K. Angami present.
Your Lordship, I have a similar prayer for item number 9.
9.
Yes, your Lord.
Yes,
Can you list this matter after 2 weeks?
you are for petitioner.
Yes, I'm for the petitioner.
Same order. Santiagna on behalf of Santiagna, so-and-so.
Deputy Lord.
Item number 1.
May it please your Lordship.
Yes,
My lord, I'm aggrieved by an due order. They don't something not, it's going to be free. My lord, I have a reference and I have a petition of that. My lord, there's a delay of 96 days.
can we use the mic?
Yeah, my lord, delay of 96 days.
Will issue notice?
One,
Will issue notice
my lord,
to the respondent.
my lord.
Will take up after 2 weeks, 3 weeks. You take his steps.
My lord.
Heard Mr. Learned counsel to the applicant. Listen, next. By filing this application under section 5 of the Indian Limitation Act 1962, the applicant pressed for condonation of 96 days delay in filing the connected civil division petition. Next. Issue notice returnable within 3 weeks. Next. The learned counsel for the applicant shall take a step to service of notice upon the respondent sole respondent were registered post with within 2 days.
2 days, my lord.
List after 3 weeks.
I remember.
So what is this?
Yes, on the last occasion, your lordship had so.
I forgot. Who is appearing for the respondent?
Here on the.
Angami. And any private respondent?
Private respondent.
Who is appearing?
He was here, Foseko, Mr. Foseko. Mr. Foseko.
Where are they? Angami is appearing. So you also you appear on behalf of
Your lordship,
what is the matter? What is the matter about?
It's regarding quashing of the FIRs. Quashing of FIRs.
Okay.
Yes.
So what was the
On the last occasion.
disagreement between this court and you?
Principally, my ground is that first these FIRs have been filed to wreak vengeance on the petitioner.
Okay.
Secondly, on the touchstone of the principle of washing of FIR, my submission, I submit that the offense of breach of trust and cheating has not been made out in the FIR. Those are the two contentions, primary contentions, and it's substantially my submissions have been heard by your lordship. And on the last occasion, your lordship made a query as to whether there is anything to show the link between these FIRs and the cases which are pending in Delhi.
Yes.
And I submit that after taking instructions, the complaint which have been lodged by the petitioner against those associates who have been visiting him while he was in custody, it was only on the threat of the threat meted out by those associates on the petitioner that he has come to an apprehension that the threat was that they have to withdraw the Delhi cases as well as these cases. It was only on the basis of the threats made out by these associates of the complainants that he has been compelled to file his complaint and to come to maybe a suspicion that the cases that are pending in Delhi these cases have been filed at the instance of those complainants in Delhi. That is the instructions that are based. Since your lordship.
This criminal petition 15 is for what? There's a direction to list along with this.
Yes.
Other
15
two
is for clubbing of the, initially when this 15 was filed, only 2 FIRs were pending. Initially when this petition was filed, only 2 FIRs were pending against the petitioner. So I filed this petition to club these 2 FIRs on the ground that the offenses alleged against me are more or less the same, breach of trust and cheating.
Okay, this criminal petition for clubbing the FIRs.
But while this petition was pending, the 3rd FIR was also instituted. And in apprehension or in anticipating because of the threats meted out to me, I've also made a prayer to club the future FIRs, future fake FIRs that may be filed against me. That is prayer number 2. And since because of the threats.
You are still in jail.
Yes, I'm still in custody.
You secure first your release and we'll hear your criminal petition. This will be question is in jail.
As far as the 2 FIRs are
the investigation is on.
Yes.
Washing of the FIR, this may be little difficult at this stage.
But since your lordship, but principally
you have the records.
Yes, lordship, yes.
What about the investigation? Why you are putting the accused in jail unnecessary? It's a criminal breach of trust.
No, Lordship,
How many days?
The first two FIRs by way of default bail.
No, this, when your client was arrested,
12 June,
12 June. What is the maximum punishment?
7. And
Charge sheet has been filed.
not yet, Lordship.
it may not be filed. Also.
So why you are not filing a bail? Instead of
I have filed the
quashing,
bail. It has been.
don't jump to the, don't jump over.
I have filed the bail.
Ah,
167, for the first two FIRs, bail has been granted under 167. As far as the Sobima, the third FIR is concerned, it has been rejected
by whom?
by the GMC, by the Learned GMC.
We'll adjourn this matter. You file a bail.
Bail application.
Lordship, otherwise.
Why since June, why?
Lordship, petitioner is not cooperating, Lordship.
Whatever, 167.
167,
CRPC.
as far as for the third FIR is concerned, 167 is yet to be over.
You are in jail in connection with the third FIR.
Yeah, now it's the third FIR.
Ah.
167 under for the
Third
first
FIR when it was filed.
4th August. So 60 will lapse by next month.
Different informant or the
Different
complaint.
informant, but more or less the same of the breach of trust.
That is the whole problem. Had it been one FIR and something like that, we could have understood. Why all this? Why so many people had to be after you?
Well, there may be.
There must be something more than what you.
There is not.
What you have.
It is file this petition.
What you have been briefed. Isn't that it?
That is why the contention.
There must be much beyond
As far as this FIR is
then
concerned,
what you have been briefed by your
there may
client.
not be anything that the prosecution will be able to prove the charges.
Hmm.
There is nothing to show that they have deposited the money, except for the mere statement made in the FIRs. The agreement, again, I've shown before your lordship that the account was opened on 15 March. So the question of even executing an agreement.
So third FIR is of different transaction.
Part of the same transaction.
Same transaction or different
Different
transaction?
transaction with different. No, Lordship, different transaction with a different person.
Different person. On the 9th of March, reported.
Same day,
Same. On the
Same.
next day,
next day.
2 FIRs on the 8th of March, apparently agreement was executed.
That's why it shows your, smartness.
It is not my smartness, so respectfully, your lordship, but because of the FIR that in
You are saying that you are disowning this FIR. That the agreement.
When
Are you
we-
disowning the agreement?
Yes, I am not a party to this agreement. I'm denying this agreement, but for the purpose of 482, I'm submitting that the allegations made in the FIR are not made out. The
For such an offense, why he should be put in jail for months together?
Lordship, there are many allegations against him. Now, certain facts, he's not even disclosing, he's not cooperating.
According to you, there is no ground has been made out by the petitioner for quashing.
No,
Are you agreeing with him that there is a ground or there are grounds?
Lordship, only after the completion of investigation that we will know, but at this stage, in view
At
of.
this stage, under 482, there is no offense that is made out in the FIR.
No, under,
This for the FIR is the agreement.
in view of
It would not have been executed by issuing checks on 8/3 when the account was opened on 15/2. Factually impossible, your lordship.
in view of Nihakari infrastructure judgment, petitioner has no case actually, Lordship,
Okay.
at this stage. Only after the completion of investigation,
Let us see.
Before your lordship,
Let us-
may I submit the?
No, you have submitted, I've heard you.
I have some authorities which I would like to
No, I'll come back to you. Let me have this first. Don't take it that you have not been given an opportunity to argue. I'll give you. Oh, this is about passing of interim order.
Yes, but
We are not on. Today we are for disposal of the matter.
Lordship, even Lordship, here, point number, if I think my Lord has already examined page, paragraph. Roman 5, Roman 3, 5.
Which one?
6,
Page?
7, 8.
Para 8,
10.
80.
Yes, par 80, Lordship.
Paragraph 80, 80.
Lordship.
And which one?
Roman 3, 5, 6, 7, 8, 9, not 9, 10, 12, Lordship. 12 will be.
No, that's what I'm saying. We are not passing any interim order. Is there any interim order?
No, Lordship. Yes, this also deals with interim order, but my Lord has already seen that.
Whether there is an interim order or not, or is he praying for interim order or not?
No, Lordship. But well, I think Supreme Court has given direction or even question FIR, Lordship. Here, my Lord has already seen, or
therefore no interim order should be passed.
not only that, Lordship, if I understand it, the content of orders correctly, Lordship. Not only that, Lordship. It's also discussed about question FIR.
According to you, the investigation is in initial stage.
Yes, the investigation is going on, Lordship. And the petitioner is not cooperating.
But basically, it's a civil dispute. If at all.
Yes. It's after
It's a breach of contract. Is not it?
Yes. Lordship, state may not have much to say after investigation, but at this stage, I think investigation should be allowed to be completed.
Mr. Alor, primary view of this court is not in favor of quashing. So, as you has submitted on the other day, I'll grant you three more weeks so that you can try some before some other bench. All right. Because you have already tried for that.
What is the lordship? We just.
Had Mr. Elirano, learned counsel for the petitioner. And also had Mr.
Yangami.
K. Angami, learned public prosecutor for the state of Nagaland. And
For the private correspondence.
for
No
respond
cases.
number 2.
Lordship, it's been 2.
On the prayer of Mr. Elirano, learned counsel for the petitioner, who wish to argue this matter before any other appropriate bench. List this matter before any other appropriate bench without me. This after 3 weeks. Normally we don't permit, but since this court has their privacy view that there's no case has been made out. I'm just we're taking a lenient view. And it may have something on you also. All right. List after 3 weeks. No, will not say anything since it is not before me. Yes. Yes. Did you appear?
No.
Huh?
I was rejected earlier.
Hmm?
Earlier, I were explained to me that was rejected.
Yes.
Now the main bail application is found.
Hmm?
Now the main bail application is found.
Hmm. So in the interim, you were directed to appear. You didn't appear.
I could not let you.
Huh?
I could not alert due to my health condition. And then I submitted one IAM because rejected.
It was also rejected. Where is that IE? No reason on. You didn't appear, no bail has been granted, you have not released on bail by the investigating or the court. Why we should consider your bail application? You are not cooperating, you are not complying the order of this court. Doesn't make a difference. Huh?
Can you see the FIR?
Hmm?
FIR. The case 13. Purely civil dispute.
Yes.
Very good.
Hmm.
With reference to the subject cited above, I, the undersigned, would like to bring to you kind notice that I am the managing director of MS Washi Construction located at Tulipsu Village, Dimapur. Sometimes in the year 2018, I had come in acquaintance with the accused, namely Sri Rajdeep Mia, who held himself as managing director of so-and-so solution. During the period of acquaintance, the accused had me into his confidence and built his trust, thereby inducing me to advance some financial assistance and assure me to invest it for the arrangement and purchase of commercial vehicles, 2 flats and plots of land at Gauhati, and some at a reasonable price. And accordingly, I had made several deposits through NFT RTGS in favor of craft amounting rupees 2 crores 69 lakhs 85,000 only since 8/11/2018 till 1/2/2019. So there was nothing, no investment at the initial stage. And earlier he has also had a complaint case that was withdrawn by me.
You read entire contents.
However, Sri Rajiv Bhai did not fulfill his promise in time as granted by him. After repeated reminder and request, I was delivered one vehicle audit, which was unable to get it registered due to lack of proper documentation. As such, I had served a legal notice to the said person, which was received on 11/3/2020 on his behalf by one whose employee, namely Ms. Sunita Kalita. And subsequently, I have filed a criminal complaint case against him in the Honorable Court of District Judicial Magistrate, 5 criminal complaint case in the so. However, taking advantage of the lockdown period, we have been making several excuses for non-compliance as to show for and appear before the Honorable Court, and as sir is knowingly trying to behave from the liability with visit and ulterior motives. Yeah, my lord, I have filed a transfer petition also before the Gauhati High Court to transfer this case. And the moment he has come to know, he has withdrawn this petition.
So that criminal petition has been withdrawn.
Right. On the same set of allegation. This criminal petition is a case of
Yes, Jibobi. Page 19. Withdrawal of the criminal petition.
Lordship,
And he has been acquitted, not only allowed to withdraw.
Lordship may kindly come to the
Page,
content.
page 19.
Lordship may kindly come to the content,
But,
page 18, starting from page
but-
18.
but ultimately court's order.
Lordship,
Accordingly, CRK so and so is withdrawn, allowed to be withdrawn, along with the said withdrawal, the accused Rajdeep is also acquitted from the liability of this case.
Lordship may kindly come to the main content, page 18.
No, ultimately, we have seen this.
Yes.
Ultimately, you have to go by the court's order.
But here,
When
the court has taken a U-turn.
all cases. And the next, how can he be allowed to file an FIR?
Lordship,
Acquitted.
here the issue is the accused, they have said that they have preferred a petition before the Honorable High Court.
Whatever.
High Court.
Last court's
And
order.
accordingly, this matter was withdrawn, Lordship.
Why
Otherwise,
you have to withdraw?
They-
If it is whether they will be transferred or not, it doesn't.
but no observations have been made, Lordship. If you go by the order, Lordship may appreciate the fact that,
But what is the last or final order accordingly? Second last para.
Lordship, but if you go by the content, Lordship, there is no such observation which has been given by the lower court below, Lordship.
Doesn't make a difference when a person is acquitted. Wrongly or rightly, unless it is put to challenge.
Lordship,
How
be
can
that
you
as,
have the same facts and same allegation?
Lordship, be that as it may, Lordship. Lordship may kindly, since they have the petitioner, the accused, they prefer the anticipatory bail before this on the Lordship.
We're not happy with the conduct. But then this criminal court, learned trial court has acquitted him. See, read this accordingly.
If I'm allowed to read, Lordship.
Yes.
If I'm allowed to.
Contents is, all these are submissions.
Yes,
Final
these are the
decision has to be
submission,
looked into.
And then here in the last paragraph, it says that right order so and so, learned advocate Nagi appear on behalf of the accused Rajdeep Goyan and submitted an application to the effect that the accused has preferred a transfer petition before the Gauhati High Court, and as such rate that the present CR number so and so be adjourned and keep in abeyance till the final disposal of the said petition moved before the Gauhati High Court. Accordingly, the matter was kept open. Hence, this application under section 2257 CRPC pray for withdrawal of complaint petition filed by the complainant against the accused person Rajdeep Goyan.
Same person.
Lordship, this is the same person, Lordship.
And the complainant and informant is same person. Out of same allegations.
Same allegation.
Same set of facts and same set of allegations.
Yes, Lordship, but the last no observation has been made, Lordship.
Forget about the observation. What is the decision of the court?
It says that accordingly, CR is allowed to be withdrawn. Along with the said withdrawal, the accused Rajdeep is also acquitted from the liability of this case. But
Yes.
however, no observation has been made in this order, Lordship. Here it is seen that, if I'm allowed, it is seen that till date, no intimation has been received from the accused person as regards the petition filed by the accused person before the Honorable Gauhati High Court. In the said application, it is averred that the accused person is knowingly evading the due process of law and has not appeared before this honorable court till date to face trial. This being the case, it is prayed that now they have taken the no observation has been made that this being the case, it is prayed that the instant criminal complaint petition be allowed to be withdrawn with a liberty to file afresh against the accused person, Lordship.
That is his submission.
Lordship, that is a submission and no observation has been made by the lower court below, Lordship, and just
But then why-
simply by withdrawing the case and saying that it has been acquitted, Lordship. No observation has been made. So this order itself is
Wrong.
Lordship, as far as this orders goes, Lordship. Since no observation has been made in this instant order, Lordship.
Then you
So
file,
because of that, they have filed.
you will file an appropriate application in that case, challenging this order, which is stopping you. If you think that this is wrong, Lordship, not only allowed to withdraw, he has been acquitted.
Lordship, my humble submission before the Lordship is, if at all, the accused by this order, if they are acquitted, Lordship, they will not have come before this honorable court filing an anticipatory bill before this honorable court, Lordship. And time and again, Lordship,
Because there is the case has been registered after the acquittal. Case has been registered.
Lordship, in a way, this order itself is not an acquittal in a sense that since no observation has been passed in this instant.
Then your the informant submission has been recorded. Whatever wrongly, rightly, it has been decided, passed. No doubt he has prayed for withdrawal of the criminal petition, along with the liberty to file fresh. But that has not been considered. Only withdrawal has been allowed and he has been acquitted.
So that this, if you go by this order, Lordship, it is just a withdrawal, Lordship, to file a fresh, Lordship.
CRPC.
And my lord,
nobody is challenging this order.
Lordship, this is 2018 matter, Lordship. FIR was filed in the year 2018.
Same set of facts and allegations.
Yes, Lordship. However, Lordship, if you go by this order, Lordship, there is no such no observation.
No doubt the conduct of the petitioner is not acceptable, but then
Lordship, even arrest warrant has been issued against the accused, Lordship. And time and again, the investigating team went to the Gauhati to arrest the accused, Lordship. However, the accused time and again absconding from the scene, Lordship. And moreover, Lordship, from the status report, it has been clearly stated that the accused keep on changing the mobile number, Lordship.
read section 257. CRPC.
Lordship,
Section 257 CRPC. If it is a different allegations or set of different facts, matter would have been different. In fact, FIR is not maintainable at all.
Lordship, in that view of the matter,
Please read, let us know.
257, withdrawal of complaint.
Yes.
If a complainant at any time before a final order is passed, in any case under this chapter, satisfies the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused, or if there be more than one accused against all or any of them, the magistrate may permit him to withdraw the same and shall thereupon accuse the accused against whom the complainant is so withdrawn.
It's permissible. The tenor of the judgment and its proper note recording manner, it's a different thing altogether. But under this provision is permissible. Once it is allowed to withdraw, the accused can be acquitted also. So how can we say that this is wrong?
Lordship,
You cannot base on the submission, you cannot rely on the submission of the parties. You have to go by the decision and the order of the court.
yes, Lordship, if you go by the order of the court, Lordship,
Order have says, finally, allowed to withdraw the complaint and then finally acquitted the accused. In fact, FIR is not maintainable at all. How can there be investigation? Not maintainable FIR.
Lordship, in that view of the matter, let it come tomorrow, Lordship.
Tomorrow.
Lordship.
Tomorrow is
No, day after tomorrow, Lord. Then
Why want the adjournment?
Day after tomorrow.
then tomorrow, Lord.
Tomorrow is DB, we are having DB two.
What is the second half?
Huh?
Second half today.
No, day after tomorrow.
Lord.
Because your conduct is also not
Lordship, Lord.
acceptable.
Time
Why
and again they have.
why you are asking for a time? What is to be deliberated upon again?
Lordship, since FIR has been lodged before the police station, Lordship, and
No, FIR itself, he has not come for quashing.
Lordship,
Which is a great application.
intelligent.
The FIR itself is not maintainable. When a person is acquitted on the same set of facts and allegations.
That we have the matter, Lordship, let it come on Thursday, Lordship. I will satisfy this Lordship, since I'm not on that line, Lordship. Today. On Thursday.
That's what I'm saying. What more is there to be deliberated upon? We are not filing any against this order of the learned trial court.
Lordship, I'm allowed to take a certain instruction, Lordship, since I was not on that line to take it, Lordship. Actually, I was on.
Mr. So your name? Huh? Rafiq. Rafiq, learning counsel for the applicant. Mr. And also Mr. VG Momi, learned counsel for learned state people, learned PP. Mr. After arguing the matter for some time, Mr. VG Momi, learned PP. Press for listing the matter after 2 days.
But
Mr. Prezilla list this matter on 21st. We'll dispose it. Nothing is there if you, unless you can make out something. But the view is that same set of facts, same set of allegations, the court has acquitted wrongly or rightly. There ought not to have been, of course, we will not quash the FIR in the bail application. That could be a good ground for granting him a bail. Yes.
Senior Police Lordship. This, for continuation of delay for 597 days.
Any objections?
Lordship, yes, Lordship. And Lordship, I file my affidavit also.
Huh?
I file my objection,
Okay.
objection to the delay.
Seriously?
Lordship,
Why is the delay?
Lordship,
How much? How many days?
597 days.
Okay. Then in that case, we should allow it to file and.
Lordship, I have received the reply.
Ah.
And then the reply is that I have not explained the sufficient cause.
Ah.
But whereas I have explained this sufficient cause on the facts and circumstances that, see Lordship, the petitioner is the daughter of the deceased. And then.
You file a reply to that objection to reply.
Lordship, if the matter be asked, Lordship. Because I will not file a reply, Lordship.
So where you have been explained? Where have you explained the delay?
Lordship, I have explained paragraph, starting from paragraph 3, Lordship. Paragraph 3, Lordship. Even this paragraph 7.
Paragraph 3.
Lordship, I have a next agreement in my main petition. Lordship.
No, why there is a delay of 500 something days?
Lordship,
7 days.
Lordship, on the basis of the agreement made between the parties, the petitioner was waiting for the perusal of the process of the pension. Lordship. But till now, I would like to bring to the notice of this report that till now, no pension has been processed. And then instead, the opposite party, he had left a place, locality. And now, as per the reply also, they are admitting that now they are settling in other state, Lordship. So on that basis, Lordship, the petitioner, since she is the only daughter of the deceased, no doubt the deceased mother stayed with the, married with the.
No, see, this, what is the impugn order what is
Lordship,
the impugn order?
impugn order is a succeeding certificate, Lordship.
Okay, so after passing of the impugn order,
Lordship, Lordship, may kindly turn to my main petition, that yes, Lordship, agreement, Lordship.
yes,
I will only point one sentence, Lordship. Page 12 of my main petition, Lordship. Here, this is the agreement, Lordship.
challenge is what is the impugn order? Is you are challenging the
Yeah, I have-
succession certificate?
Yes, Lordship, I have challenged the impugn succession
The impugn
pass by
succession certificate shall be granted to the September 2021, yes.
Yes.
Then
So Lordship, see, Lordship, may kindly turn to.
it says granted against the in favor of respondent number 2.
Yes.
The sole respondent.
Yeah, so responding, Lordship.
Okay.
Now, why I'm coming to before this report is that basis, my basis, Lordship, at page 12, next section, page 12 of my main petition.
Yes.
See, Lordship, this is there are several agreements. So I may be allowed to make the read out, Lordship.
No, you just make a submission.
Lordship.
Don't read this.
So,
After the succession certificate was granted in favor of the sole respondent,
Lordship,
you entered into an agreement
Lordship, this is the agreement, Lordship.
saying what?
Lordship, that the paragraph 7, Lordship, we see paragraph 7. In case Shiri Yansi, that is the respondent, Lordship, of the party, husband of Lefty Asanga run away from the properties and money shall be seized and he will not have full right to claim ownership. Now, see, Lordship, see, being from the non-local, with the apprehension that he have made this agreement. And then, no doubt, you were husband and wife after the expiry of their first husband of this late deceased, this Asanga.
Who is the petitioner?
Petitioner is the daughter of this deceased, daughter of the deceased.
And
And
respondent
Respondent, Lordship,
is the wife.
Lordship.
Respondent, who is the respondent?
Respondent is the opposite party, Lordship.
Opposite part, who is the opposite part?
Husband,
The husband.
the second husband. The first husband unfortunately expired. And then with the earlier husband, there was one daughter, the only daughter. And then without daughter, he married to another man, that is the present opposite party, who is the non-local, Lordship. And then because of that, there was no issue, there was no sibling with the second marriage, in the second marriage.
Prosecco is very complicated. We'll condone the delay.
No, Lordship.
We will go with the merit.
Lordship.
Lordship, even
And then, Lordship, as I say, as I submitted, this agreement is very clear. Because of that facts and or else if and then till now, the pension process has not.
So you are the second husband.
Lordship.
Lordship.
The
And
succession.
succession is the disease. Who is the disease?
This is the mother of the present petitioner, Lordship.
Present petitioner.
Yes, Lordship. She has the interest on in the property, Lordship. That is where in the succession objection, I was made as a party, but no formal issue was issued. While issuing the succession certificate.
You are the second husband.
Lordship.
And the petition is your stepdaughter.
Lordship.
Son or daughter?
Yes, yes.
Daughter,
Yes.
stepdaughter.
The stepdaughter.
So you being a second husband, succession was granted in your favor.
Lordship,
And there was an agreement
Lordship,
between you and the daughter and the
between the family members,
daughter and the
daughter,
step brother.
daughter, and then the opposite party, and then in presence of some witnesses.
Yes. So in the agreement, what does it say? Huh?
Lordship, I may be allowed to read the words.
Not whole. Yes.
Lordship, without going to the married Lordship.
In
Please,
case the
Lordship.
youngster husband of late T. Asenba, run away from home, the properties and, okay. Youngster is you.
Yes,
Yes,
Your Lordship,
young C,
young season Tom.
youngster.
Lordship.
So he has run away.
Lordship, and then till now, no pension process has been approved by the state. Because he has taken all the papers, and then now almost more than 2 years.
So
And
see,
it's a
this
business
second husband is permissible under the custom.
Lordship,
Let us see the Succession Act, who is entitled? Succession Act. You have the, then, unless you can show that under the law you are entitled, you can file a petition.
no, Lordship, as per the succession of act of
Whether the second husband is entitled to get the succession certificate, that is the issue. Waseko?
Lordship, if the petitioner is aggrieved with the succession,
What is the provision?
the petitioner should approach the one Lordship that she cannot come before the Honorable Court for an appeal.
Why?
First, Lordship,
Alternative remedy is there.
Lordship, yes, Lordship.
What is that? What is that?
383, revocation of certificate. The certificate granted under this part may be revoked for any of the following causes, namely that the proceedings to obtain the certificate were defective in substance, that the certificate was obtained fraudulently by making of a false suggestion or by the concealment from the court of something material to the case. C, that the certificate was obtained by means of an untrue allegation of fact essential in point of law to justify the grant.
Have you approached, to whom it has to be approached?
384.
The authority who has granted.
Yes, Lordship.
There's no book. Read that provision where that the persons who is entitled for succession, claim for succession certificate. Will come later, this 383, 84. I mean 84, 83 will come later. First you.
Yes, Lordship.
Sir, this is your case. Why you have not come with the books?
372.
Lordship, I am.
You are on internet. Google.
Lordship,
Google sometimes it's mislead, huh? Be careful. You get everything, but sometimes it's mislead.
Lordship, I will be allowed to read. Lordship, 372. Section 272 says that application for certificate. Application for such a certificate shall be made to the district judge by a petition signed and verified by or on behalf of an applicant in a manner prescribed by the Code of CPC for the signing and verification obtained by or on behalf of the claimant and setting forth the following particulars, namely the time and date of deceased, the ordinary residence of the deceased at the time of his death, and if such residence was not within the local limits of the jurisdiction of the court to whom the application is made, then the property of the deceased within those limits, the family or other near relatives of the deceased and their respective residents, the right in which the petitioner claims the absence of impediment under section 370 or under any other provision of this act or any other enactment to the grant of the certificate or to the validity thereof if it were granted, and the debts and securities in respect of which the certificate is applied for. If the petition contains any evidence which the person verifying it knows or believes to be false or does not believe to be true, the person shall be deemed to have committed an offense under section so and so. True, an application for such certificate may be made in respect of any debt or dues to the deceased creditor or in respect of portions thereof. Restriction.
What the persons who can apply for the succession certificate? That is I'm asking, sir. Not the
The
person
family or any other relatives.
where it is.
372 C.
Hmm?
372, section 372, Lordship. 372 C.
That's why I'm asking. The second husband is permissible. Can he be called a members of the family? Huh? Where is the order of the district judge refusing to revoke or cancel the, where it is?
Next year, 2 of my main petition, page 11. Page 11.
No, this is certificate granting to respond number 2.
Lordship.
Where they refuse to revoke and reject, cancel.
No, Lordship,
Yes, Lordship.
Lordship, I'm here before this report under this 384, Lordship.
384 is against the order refusing to cancel or revoke. Read.
Exactly, Lordship.
Subject to other provisions of this part, and the bill shall like the High Court from the order of a district judge granting, refusing, or revoking. So this is the granting of such things. A certificate under this part, and the High Court may these things by its order on the appeal that declare the person within the certificate should be granted and direct the district judge.
No, then you read, it has to read along with section 383.
Yes, Lordship.
A certificate granted under this part may be revoked for any of the following reasons.
That the proceeding to obtain the certificate were effective in substance, that the certificate was obtained properly by making of a false accusation or by concealing from the court something material to the case, that the certificate was obtained by means of an untrue allegation of a fact situated in point of law to justify the grant thereof, though such allegation was made in ignorance of inadvertently, that the certificate has become useless in inoperative through circumstances, that the decree or order made by the company board to sue or other proceeding.
See, you can, it falls under subsection clause C.
Lordship,
That the certificate was obtained by means of an untrue allegation of fact essential in the point of law to justify the grant thereof, though such allegation was made in ignorance of inadvertently.
Lordship, that I have explained because in my main petition, because he being from the non-local, he has that he being from the non-local, non-residents of this place, he has obtained that he is the permanent residence of one village, Lordship. I have already make allegation.
No, you make this before the district judge who has
no, Lordship. See, since as per this 384, here it is
it includes granting.
granting of this.
But then
And then Lordship,
first you have to approach.
no, Lordship,
Yes, Lordship.
here in the process, in state, is that the issuance of succession certificate, it is itself, it's an order, Lordship. Basing on that, all the pension individuals in that, it
This is correct. It can be revoked also.
yes. So that is why
The revocation power is to the district, the person who has issued the certificate. You file an application for revocation. There's a provision.
Lordship, that is why I am before this under 384.
And if he refuse to revoke the certificate, then your appeal may lie.
Yes, Lordship.
No,
Exactly,
Lordship.
Lordship.
As
The
per my-
appeal
Unless you show that it has been granted.
Lordship may kindly allow me to make some submission that, see, this section, it's related to the, if I'm asking before this report for order or direct, necessary direction for revocation or maybe Lordship. So Lordship,
Just because the word granting is also mentioned in 384, appeal just doesn't lie. Automatically it doesn't lie. You approach the concerned court, district judge who has issued this certificate.
Exactly, Lordship.
If he refused to revoke it,
Then yes.
then you may file an appeal and
For some High Court, Lordship.
I agree, there's a granting is also there in 384.
Lordship. And then Lordship, see, there is no such order or other order except the succession certificate. And then
Therefore, no appeal.
and
It's
then-
not only granting, it's also refused to revoke.
That is why, Lordship,
You approach the court, district judge.
Lordship, I'm saying that since the succession certificate is the only order, basing on all the pension. That is
What I'll do is, I'll condemn the delay and dismiss your appeal on the ground that there's the provision for revocation by the district judge. It's one thing, it's the same thing, it's nothing. It will be in no-case order. So withdraw and file.
Lordship. If Lordship, may please to confirm my plea also.
Huh?
May please confirm my plea also, Lordship.
Huh?
May please be confirmed by plea also.
The one for the dismissal of the appeal, why should condemn the delay? You withdraw and file the appropriate, I'll give you a liberty to approach the appropriate recourse to the appropriate forum.
But Lordship, according to me, this 354 clearly shows that the only appeal lies with the High Court, Lordship.
Against
Against the.
there is no order for refuse to revoke.
Because as such, I have not come across because succession certificate.
Then forget about, you just make your submission on the granting. Just because it has been granted, you will approach the High Court. That could not be the intention of the legislature.
Because Lordship, basing on that succession
When
certificate,
there is a provision, you have to read.
Lordship. Because
What about section 383?
Lordship.
You have mentioned 383.
Yes, Lordship, I have.
Refuse to, no, appeal lie against the granting, refusing to revoke. It's not only granting. Granting and refuse to revoke.
Lordship, my humble submission is that since I have never come across such other order, except the succession certificate.
When you have not approached the court, how can he can sue motu pass in revocation or refusing to revoke the order? You approach the district judge who has issued the order. If he refused to revoke or cancel under 383, then only 384 lies. All right. What do you say?
Lordship, I leave it, Lordship.
Huh?
I leave it to Lordship. I leave it to Lordship.
No, not mine. Rather, I leave it to you. If you argue under merit, I'll dismiss the petition, first appeal, as I was probably found that there is a provision for application for revoking the successor certificate granted by the district court.
Liberty to approach, Lordship, liberty to approach before.
Heard Mr. So-and-so learning counsel for the petition. Also heard Mr. Prosecutor for the learning counsel for the response. Mr. Your name, please?
Yes, Temjan.
Yes, Temjan, learned counsel for the petition appellant. After arguing the matter for some time, press for withdrawal of the applications and the appeal with a liberty to approach the appropriate forum. Mr. Next. In the facts and circumstances, considering the submissions and the facts and circumstances, the prayer of the petitioner, the learned counsel petition is allowed. Mr. Accordingly, these applications and the appeal stands closed on withdrawal with a liberty to approach, with a liberty to recourse to the appropriate forum, if so advised. That's all.
Are you blessed?
It's 12 o'clock. Just take a break. This is just 5 minutes.
Yes.
Who is appearing?
Paying for the petitioner, Lordship.
Hmm?
In this matter, I'm seeking direction to the Learned Civil Judge Kohima to dispose an IA which has been kept reserved for orders since 2021, since April 2021.
Hmm.
The order is that the order reserving the application is at page 21 of the petition, dated 27th April 2021. And it's been more than 2 years since the IA has been reserved for orders.
None appears for the respondent.
No, they are represented.
His lordship, I have instruction to appear for 1 and 2.
Hmm. Who is 1 and 2?
The Nagaland State Transport.
Hmm. So,
We have no objection.
do you have the judgment of the Supreme Court?
Yes, I do. The one I have is 2017 SCC 318.
No, latest one. Find out the latest one.
As far as the civil courts are concerned, I'm afraid I'm not been able to place any judgment, but please. But here in this matter also the Supreme Court has at paragraph 8. Paragraph 8. Below precedent D, the pronouncement of judgments.
Paragraph.
Paragraph 8.
Hmm?
Paragraph 8. The last part of the judgment, paragraph.
The pronouncement of judgment civil court, civil case should not be permitted to go beyond 2 months.
And
This is for criminal, no?
first part is deals with the criminal petition, CRPC, and then that part deals with civil cases.
What is the relevant provision on CPC?
Order 20. Order 20 rule down.
Is there any notification from the High Court after this judgment? Which notification there?
Order 20 rule down.
We want that this should be disposed of today.
Yes, because I filed this petition in the month of July and
There's
that's here.
You have filed an application on Dusty. You have served Dusty
Yes, sir.
service, huh?
I
So respond number 4. Heard Mr. Learned Counsel for the petition. And also heard Mr. Oh, you are for 1 and 2.
Yes, Lordship, on behalf of Mr. City Jamir.
MS ensure Learned Counsel for the respond number 1 and 2. And
Lordship, and for respondent number 3,
Mr.
Kiangami.
K. Angami, Learned State Council for respond number 3. Non-appeals for respond number 2. Respond number 4, despite service of notice. Despite receipt of service by way of Dusty, for which the petitioner has filed an application affidavit to that effect. Next paragraph. By filing this application under Article 227 of the Constitution of India, the petitioner has prayed for directing the London Civil Judge Senior Division Kohima to dispose of CMC number 2/2020 in civil suit number 2 of 2027. For an order which has been kept reserved since 27/2021. It's an order 27/4/2021. This is an order for.
That's 2021.
What is the civil miscellaneous case was about?
That is for.
You just give me the brief in nutshell. In brief.
I filed this application to amend the relief portion of the plaint. Arguments were heard, the written objection were filed, and it was resumed on 27th. After that, despite listing the matter for orders by the Civil Court,
It has not been pronounced since, and because of that only I filed this petition.
When it was heard,
27th April 2020.
27/4/2020. Next paragraph. The brief facts is that brief facts of the case is that the petitioner has filed a civil suit before the Court of Learned Civil Judge within the Senior Division, Kohima, Nagaland, which has been registered as and numbered as civil suit number 2 of 2017. The suit has been filed praying for permanent injunction against the defendant. Respondent number 123. And not to interfere with the peaceful position and occupation of the plaintiff's and petitioner's land and house. Yes, sir. Pursuant to as many as 14 issues have been framed by the learned trial court on 16/11/2018. The petitioner was examined on 28/11/2009. As on that, the 11 witnesses, there is 5 plaintiff witness, 6 defendant which is yet to be examined. Next paragraph. After the examination of the petitioner, you are the plaintiff, correct? An application was filed being CMC within bracket civil miscellaneous case number 2 of 2020 on 27/1/2020. By the petitioner plaintiff Mr. By plaintiff petitioner seeking amendment, seeking to amend the reliefs read for in the plaint by adding the relief of decree for declaration of the title. Objection was filed by the respondent defendant number 1, 2, and 3. Mr. The CMC number 2 of 2020. The application CMC number 22 was heard by the learned trial court on 27/4/2021 and reserved the judgment reserved for over. According to the petitioner, the learned court is yet to pass any order in CMC number 2 of 2020, despite being listing the matter for pronouncement of order in the weekly cause list almost every month, ever since the matter was kept reserved on 27/4/2021. just to hence this petition under Article 227 of the Constitution for a direction to the learned civil judge within the senior division Kohima to pass the order in CMC number 2 of 2020 arising out of civil suit 2020 within a specified time frame and not pass any other order within time frame. Mr. Next question. Mr. Learned counsel for the petitioner submits that years have already been collapsed ever since the order was reserved in CMC number 2 of 2022 arising out of civil suit number 2 of 2017. On 27th of 2020. He submits that the order not being pronounced in the application. The trial in the main suit is being unjustly delayed for more than 2 years. Accordingly, therefore, he prays for directing the learned senior division, the next civil judge senior division Kohima to pass appropriate orders, to pass the order in CMC number 2, 2020 within a stipulated period of time. Next paragraph. Both Ms. So-and-so learned counsel for respondent 1 and 2 and Mr. K. Angame, learned state counsel, has no objection for such a direction from this court. Yes. Before that, before their state, praise for an Mr. L. Iralo, learned counsel for the petition, has placed reliance on the judgment of the Honorable Supreme Court in the case of Anil Rai versus State of Bihar, reported in 2001, 7 SCC 318. Then there no objections and so for direction. I have considered the submissions made by the learned counsel for the parties. Next one. In the case of so-and-so, Supra, Anil Rai, Supra, the Honorable Supreme Court has observed as follows. Para 8, 9, and 10. 10. 8, 9, and 10. You quote the 8, 9, and 10. This quote is not this code, next para. Order 22. Of CPC 908, Code of Civil Procedure 908 deals with the judgment and decree, which I have to cut the same. Order 22, Rule 1. Order 22, rule 1, 2, and 3. Order 20. Order 20, sorry. Order 20, right? Just go to rule 1, 2, and 3. Next one. Having considered the submissions and the law laid down by the observation made by the Honorable Supreme Court, and as well as the provisions of Order 22, Rule 1, 2, 3. This code is of the considered view that it is appropriate to consider view that the learned civil judge senior division learned civil engineers division is under obligation to pronounce the judgment of order within a period which is required to be pronounced as provided under the law and the obligation of the Honorable Supreme Court. Yes, in view of the above, it is directed that the learned civil division Kohima shall pronounce the order in CMC so and so arising out of so and so, which has been kept preserved since 27/4/2021. Yes. Accordingly, this petition is allowed and disposed of. That's all. Within 1 week or 2 weeks. Would not say within 1 month we'll see. Because we understand. You should understand our predicament also. Within 1 month. Yes. All right. It is either to accept or it is to reject. Is not it? Yes. Amendment. You are praying for amendment. Either it has to be rejected or it should be accepted. Yes. That's all. Accordingly, you will be allowed or you will proceed. I'll add something, some sentence here and there later. We'll add something, some more there and there. You just wrap it up. Send back the else here. You just 2 o'clock.
May I please motion?
Yes.
My lord, by order dated 26/6/2023.
Yes.
The state was directed to file additional affidavit, my lord.
Yes.
The motion may kindly see in my affidavit. in para 2.
You have filed an initial affidavit,
Yes, my lord.
where it is.
Yes, so my humble praise, my lord, basing on this paragraph, the medical clause, my lord.
Paragraph 2,
Yes, paragraph 2 of my additional affidavit.
just read it.
May I read, your lord?
Yes.
That it is pertinent to state that the department on proper scrutiny on the records from the office of the medical superintendent, Longlang, it has been found that late N. Sharma, driver, petitioner father was regularized by order dated 1984. Further, it is also back to state that due to administrative oversight, the earlier affidavit in opposition was filed. In fact, in the main writ petition, the petitioner had not made any amendments or enclosed documents stating that the petitioner father was regular employee, but only in the affidavit in reply filed by the petitioner had annexed pension document claiming that her father was a regular employee. However, as per the available records, the petitioner was found to be eligible to consider on compassionate ground. Therefore, the petitioner's case shall be considered as and when her turn comes. So,
My lord, I am the only lone and only person applicant applied for this post on compassionate ground in the district of Long under medical department. And this month, one person is due to retire. Therefore, I may be given this opportunity by appointing.
Who is going to retire? See, this compassionate appointment is not a right as such.
Yes, but my lord, no one has been appointed on compassionate ground in the district of Long. And I am the
But
lone.
unless you have the
Yes,
right to appoint under this, under
yes,
the same
I have
post.
the right in my application, my lord.
No, it's okay.
Yes,
See, compassionate appointment
yeah, there is.
is not a matter of right.
My lord,
You cannot claim it's a matter of right.
my lord, it is a matter of right.
It has to be, no, it's not a matter of right.
My
It's a-
lord, I have an this is a matter of fact, 50-50.
Huh?
50-50. Compassionate appointment is 50 and other appointments are 50.
Where it is?
It is, my lord, page 27 in my application.
Application,
Petition.
repetition.
Yes. So this is the office memorandum. Page 27, my lord.
Yes.
Is para to my lord. It should be either spouse or son or daughter. And then para.
That's why they say they'll consider as and when your turns come.
Yes, my lord.
Huh? But as a matter of, it's not a matter of right that you should be appointed on compassionate basis. The state has the policy. Therefore, you may claim for a compassionate appointment, but it's not a right as such.
My lord, if there is vacancy, there is a right. My lord may come to para 4. That is a
No,
specific instruction.
that will not say that it should be appointed this post, that post. The government will consider as per the policy office memorandum,
Yes.
whether you should be appointed or not. His father was
driver, serving as a driver. Yes,
a regular driver,
yes, my lord.
regularized,
Yes,
and he died in harness.
yes,
Yes, right, harness.
Okay. Will direct them to consider in terms of the prevalent office memorandum
yes, ma'am.
of this state. That's all.
Yes, ma'am.
Nothing more than that.
Yes, ma'am.
Nothing. Heard Mr.
M. Sir.
Learned counsel for the petition and also heard
E.T. Paphom.
E.T. Learned state council.
Yes, my lord.
For respondent number.
All the
For
respondents.
all the respondents. For respondent number. For the state respondents.
Yes.
Next paragraph. By instituting this application, the petitioner has prayed for a direction for appointment of any grade 4 post on compassionate ground in terms of the office memorandum number AR-B, AR-8/8/78 dated 17/9/2015. That is page 17, Page 17.
27.
No, sorry, 27, page 27. 27, page 27. Is the continuation. As the father of the petitioner was working as driver, died in harness on 4/1/2015 while rendering service while he was serving under the establishment of district hospital Longling, Nagaland. Next paragraph. The case of the petitioner in nutshell is that the father of the petitioner, late N. Sharma, alias Teddy Temjen Form, was a regular government employee serving as the driver under the establishment of district hospital, Longling, Nagaland. Who died in harness on 4/1/2015, leaving behind his unemployed wife and 4 children, including a petitioner, who were not employed in any government office. You are the son,
I'm the daughter, my lord.
eldest daughter.
Eldest.
Daughter is also
Yes, my lord.
entitled.
Yes.
Next paragraph. The petitioner being the eldest daughter of late, her father late. Then you have to change that his, I said his, no, it should be her. Her father submitted an application to the principal director, Director of Health and Family Welfare, Nagaland, for appointment on any grade 4 post on competitive ground. However, the competition upon on 13/6/2019. Mr. You have delayed yourself. Your father died in 2015 and your application in 2019.
I faced so many
Police state.
hardship, my lord, that is so risk. My mom was sick. Even I have to look
Since-
after her.
However, the respondent authorities has not considered her case. Has not considered the grievance of the petitioner. Hence this writ petition for a direction, for appropriate direction to the respondent authorities for appointment on any grade 4 post in the state government on compassionate ground. Any, no submission is required to be recorded because we are directing, he is accepting it.
My lord.
What you have filed, what you have said in the affidavit? Nothing.
No, my lord, here earlier,
We'll just record this.
yes, this paragraph, the additional affidavit in para two.
Mr. So-and-so, learned counsel for the learned state council. While referring to the additional affidavit filed on behalf of the state respondents. Submits that the case of the petitioner has been found to be eligible to consider on compassionate ground. Therefore, the petitioner's case shall be considered as and when her turn comes. Please. The statements made in the additional affidavit is reproduced here in below. Here are two of additional affidavit. You put that here. Next, having considered the submissions of the learned counsel to the parties. This court is of the view that the writ petition be disposed of with a direction to the respondent authorities to consider the case of the petitioner for appointment on appointment in any grade 4 post on compassionate ground in accordance with the relevant policy of the state government. Should we give some time
Yes, madam.
with
At least 4 months, madam.
wisdom? The consideration shall be the state respondents are directed to consider the case of the petitioner for such appointment within 4 months. Because if you say there is a vacancy in all, you consider.
Yes, one person is due to the guy on 30th.
We'll say, we have just said, we consider as per the policy of the government.
Yes,
It's mine.
The writ petition is disposed of. With the above direction, the writ petition stands disposed.
much obliged.
Bless you.
Okay.
May please, Your Lordship.
Yes.
Lordship, here the petitioner is aggrieved by the order dated 8 June 2020 issued by the state respondent for recovery of withdrawal of pay from the pension benefit of her late husband who retired as PA to DC, Lordship. Who retired as PA to DC, Lordship. From the- Yes, Lordship.
Retired as a PA to DC.
Yes, Lordship.
So,
Lordship here, if I may take your lordship to my annexures, lordship.
yes,
Lordship here,
this is for what? You are seeking for, what is your prayer?
lordship here, the petitioner is seeking for is agreed by the order issued for recovery of excess drawal, lordship.
Okay,
Lordship. From the pension benefit of our late husband. Lordship.
yes.
So lordship here, annexures 1 page 17 lordship. Here
Yes.
the petitioner was late husband was initially appointed on the basis
I
of
cannot read this.
lordship, the type copy is
Okay, you show the type copy,
18 page 18.
So
lordship here, he was appointed on contingency basis lordship initially. And again, lordship, annexure to lordship.
DBs, what is DBs?
DB is Dubashi's lordship.
Devasis.
Yes, lordship.
Devasis,
Yes, lordship.
It's a kind of, it's a court, customary court.
Yes, lordship. They are, yes, lordship. They are employed. Yes.
Devasis is a customary court.
It's a kind of the customary court, lordship.
It's a kind of, or it's a
It's
customary?
a customary court, lordship.
Yes.
So, lordship, he was appointed on contingency basis. Lordship.
Your father,
Lordship, husband, lordship.
husband,
Yes,
husband,
lordship.
you are the wife,
Yes, lordship.
okay,
So, lordship on again on page 19, annexure to the type copies of page 20, lordship.
yes.
Here again in 1983, lordship.
So regularized,
Yeah, no, lordship, he was freshly appointed, lordship.
okay.
Lordship, yes.
Appointed as interpreter grade 2 DB
Yes,
on
lordship.
regular basis.
Yes, lordship. And the service book was only opened in 1983, lordship. Here only, lordship. The service book of the late husband was opened only in 1983, lordship.
82,
1983, lordship.
83,
Yes, lordship.
okay.
So, lordship, and again, he was also promoted to.
So we are not concerned about 1980 appointment, it was contingency.
Yes, lordship. So here now the
So
government,
it was monthly wages of 220 per month, it has nothing to do with it.
lordship.
So your thing is your actual will start from 1983 when
Lordship.
your appointment on regular, I mean, the first appointment
First
is
appointment, lordship.
interpreter grade 2 DB.
Yes, lordship.
Earlier just say contingency on DB.
Yes,
It is a post, is it a post? Interpreter grade 2 DB,
yes, lordship.
is a post,
Yes, lordship.
okay. Yes, then
So in meantime, lordship, he was again promoted, lordship, in the year in the year 2001, lordship.
to the post of,
He was given the officiating permission, lordship, to the grade 1 DP, lordship.
okay, grade 1 DB.
Yes, lordship.
It's a promotional post,
Yes, lordship.
okay.
And again, lordship.
Officiate,
Yes, lordship.
Then,
Again, he was again promoted to DP special grade, lordship, in the year 2012.
this is
lordship.
further higher promotion,
Yes, lordship,
okay,
which is at annexure 4, lordship.
okay.
And again, lordship, he was again promoted to PA. The last promotion was PA to DC in the year 2016, lordship.
So many promotion,
Yes, lordship. So,
So today court promotion, special grade,
DB, lordship,
this to the post of political assistant, okay, PA.
PA to DC, lordship. So after
When you were promoted special, okay, yes,
annexure,
2012, yes,
he was promoted to PA to DC in the year 2016, lordship, which is
Yes.
at annexure 5, page 624, lordship.
yes, yes,
So in meantime, lordship, after in the year again 2018, lordship, he retired from the post, lordship, PA to DC, lordship, which is at annexure 26, lordship. 7, lordship, page 26, lordship.
what is page 25?
Lordship, this is the communication that was communicated to the
Appointment
Yes,
of promotion, communication, deputy commissioner
yes, lordship.
regarding your promotion is to PA.
Yes, lordship.
Yes.
So it was released
26 is,
26 February release order, lordship. Annexure 7. He was released as PA to DC.
you retired on 1st of
First
March 2018.
18, lordship. Yes, yes, lordship.
Why do, I mean, overwritten is 28 February 2000,
Lordship,
15?
yes, Lordship. This is a fresh release order that was issued by the state respondent, Lordship.
Yes.
So, this was the first release order, Lordship. So the issue started when the pension documents was furnished to the DC, to the Commissioner, Lordship. So may I take your Lordship to the main issue, Lordship? Annexure 9, Lordship, page 28, Lordship.
Page 27 is what?
Lordship, this is
Submission
the
of pension papers
yes, submission, yes, Lordship, to the Deputy Commissioner, to the Commissioner, Nagaland, Lordship,
by the,
by the ADC.
yes,
By the DC, Lordship.
okay.
So Lordship, here the Commissioner, Lordship, sought some clarification, Lordship, with regard to the petitioner's stay in service, Lordship, marriage, Lordship.
Yes.
To the Deputy Commissioner, order letter dated 18 June 2018. To the Deputy Commissioner, subject clarification sought in respect of Shri Hambok from PA to DC Longland seeking release order. So on the subject cited above, I am directed to forward here with the Home Department letter so and so dated so and so regarding clarification sought in respect of Shri Hambok from retired PA to DC Longland seeking for the release order. It may be mentioned that the release order of Group A and B officers are issued by the administrative head of the department HODs, whereas only for the Group C and D employees are issued by the head of the department HOD. Further, first appointment as contingency shown in the first appointment order dated 22/1980, while recording the service shows 1/3/1983. In this regard, you are requested to clarify whether there was any break in the service after the initial appointment, Lordship. So, Lordship, after this clarification was from the department, Lordship, the Deputy Commissioner Longland, Lordship, wrote to the Commissioner, Lordship. The clarification is page 29. The type copy is at page 30, Lordship. Married, Lordship. To the Commissioner, clarification in respect of so and so Longland with regard to issue of release order. With reference to the letter number so and so dated so and so subject cited, I have an honor to state that Shri Hambok from PA to DC under the establishment of Deputy Commissioner Longland has been released from the office with effect from 1st March 2018 on retirement from active service on superannuation. Point one, there is no record in this office regarding the first appointment on contingency basis dated 24th February 1980, and if there was any break in service between his first appointment and appointment on regular basis dated 9th February 1983. There is no mention in the service book that he was earlier appointed on contingency basis. The record shows that he was appointed with effect from 1 March 1983. This has led to an overstay of 3 years, that is 9 February 1980 to February 1983. Therefore, authority may like to consider the overstay period of condemnation since it was none of his fault and there appears to be a lapse in the recording in his services book and take the date of his regular appointment as entry period. This is for your further Lordship. So after this, Lordship, the matter was put up before the PNR, Lordship, which is at Annexure 11, Lordship, page 31, Lordship. So, Lordship, the matter was put up before the PNR, and here the PNR has stated that for condemnation and also for the payment that was paid during the overstay period, Lordship. However, Lordship, here the petitioner is not aggrieved for condemnation, Lordship, only for the recovery, Lordship. So, Lordship, here the PNR put up before the cabinet, Lordship. May I read the PNR?
Yes, page 31.
Yes, Lordship. The matter has been examined and the following is conveyed. Point number 1. The Home Department is advised to initiate necessary actions whereby in suppression of the order dated so and so, the date of release from service of the official Mr. Hambok from PA to DC Longland is amended from 1/3/2018 to 20/2015. From where the release order has been amended, Lordship. Point number 2, clearance is also accorded for condemning the period of overstay in service of 3 years with effect from 1/3/2015 to 28/2018 in respect of the officials concerned, subject to the approval of the cabinet and the condition that point number 8, the period of overstay in service with effect from 1/3/2015 to 28/2018 shall not be counted as qualifying service for pension. Number B. The pay and allowances availed during the said period of overstay in the service shall be treated as honorarium and no recovery thereof shall be made. So, Lordship, further, this was put up before the cabinet, Lordship, which is at page 32, Lordship. Page 32, Lordship, the next annexure 12.
Yes.
So Lordship, the matter was put up before the cabinet, Lordship, as cabinet memorandum, Lordship. May I read, Lordship?
Yes.
Dated November 2018, subject condemnation of a period of overstay in service in respect of so to this under the establishment of Deputy Commissioner Office. The Office of the Commissioner Nangled forwarded the clarification in respect of Shri Hambok so Deputy Commissioner regarding the release order copying so. While preparing his release order in 2018, the date of retirement of Shri Hambok was prepared as per the entries in his service book, in which his service entry is dated 1/3/1983, and not as per his service entry as contingency paid GP based on the appointment letter dated 20 February 1980, which was not available in the office record and thereby indicating overstay in service of a period of 3 years. The matter was endorsed to PNR department for examination, and it has directed the Home Department to amend his release order dated 28/2/2005 and not as 1/3/2018, continuing the period of overstay in service of 3 years with the condition that the cabinet approval should be obtained, and the period of overstay in the service from 28/2/2015 to 1/3/2018 should not be counted as qualifying from service for pension benefit at the pay and allowances availed by him against the said period of overstay in the service should be treated as honorarium. The clearance and recommendation of the PNR department may be sent to the annex, may be sent, Lordship. Thereafter, Lordship,
Cabinet has said no condonation.
yes, Lordship.
And it should not be overstay period which we have drawn, the pay and salary should not be treated as honorarium.
It should be treated as honorarium. It should be treated as
No, it says should not be counted as qualifying service for the pension and pay and allowances availed by him.
should be treated as
Okay.
yes, Lordship.
Okay.
So, Lordship,
But this 3 periods should not be counted for the for
yes,
pension.
Lordship.
Yes.
So, Lordship, here again, in my next annexure, Lordship, annexure 13, Lordship. The condemnation that was sent before the cabinet, Lordship, the rejection was given in this letter, Lordship. However, no specific mention was made for recovery of regarding the recoveries, Lordship. May I read, Lordship?
Cabinet has not said anything about recovery.
Yes, Lordship, it's in the next. They have just mentioned about non-condemnation of the stay, Lordship.
Okay.
May I read, Lordship? Letter dated 13 November 2018 to the Secretary to the Government of Nagaland, Home Department, Nagaland, Kohima. Subject condemnation of period of overstay in service in respect of Shri Hambok from PA to DC under the establishment of Deputy Commissioner Office, Nagaland. Sir, I am directed to refer your cabinet memorandum so and so dated on the subject cited and informed that the cabinet meeting held on 26 November 2018 has taken a decision that the cabinet will not entertain any proposal for condemnation of overage, Lordship. This was the letter conveyed, Lordship.
Yes.
And after this, Lordship, here the other annexures that are communication between the state respondents, Lordship, regarding for non-condemnation, Lordship. Lordship, may I take you to Lordship, annexure 17, Lordship. Annexure 17, page 37, Lordship.
Page
37, Lordship. Annexure 17. Yes. This is the second release order, Lordship, that the first release order that was issued as per the cabinet memorandum, Lordship.
Yes.
So, Lordship was released, it was freshly again released, Lordship, and as special grade DP, Lordship. And he was released with effect from 28 February 2015, Lordship, and not as earlier, Lordship. So, Lordship, here the petitioner contention is not about for condemnation, Lordship. She is aggrieved only for the recovery that for the service that has been rendered by her late husband, Lordship. And Lordship, the law in this respect is settled that recoveries cannot be made against when the person is retired, Lordship. And the order was issued only after his retirement, Lordship. It came to light only when the pension process was making, Lordship. So it's my humble submission that if this release order can be quashed, Lordship.
This retirement is which age?
65 lordship.
60 years,
60 lordship.
60.
Yes, lordship. 60 lordship.
So if it
Your
is,
lordship, 60 or 35 years of land of service.
that's why, that's why. Otherwise, if you counted the 3 years as a
Lordship.
contingency, if it's only based on the years, number of years,
Yes, yes,
then you could not have overstated something like that.
yes, yes.
But if it is
Land of
60
service
years,
is involved.
60 years or 35 years, whichever
Yes.
is earlier,
Yes, yes.
Yes, lordship. The petitioner has been retired from the land of service, lordship.
you will have that judgment.
Yes, lordship. I have.
Rafiq
Rafiq Masih, lordship. 2015.
Masi,
Yes. Lordship.
just read
I
that relevant person.
In fact, lordship, I have
If-
any, yes. Lordship.
Is it grade 4?
No, lordship, it's not grateful, but
No, it is a grade 4. Your father,
No.
husband was a
no, lordship.
grade 4 employee.
No.
He's not grateful, it's a great.
PA,
it's great.
PA is what?
P is grade 2,
Grade 2.
grade 2. Special grade is grade 3.
Okay.
Uh, 2015 for SCC.
Rafiq Masi.
Yes, lordship. Lordship, I'm relying on para 10, 11 in it. However, lordship, I'll rely on para 18, lordship. Page 345, lordship. Married, lordship.
Yes. Para 18,
Para 18, lordship. It is not possible to postulate all
para
situations.
18, Roman 2.
Lordship.
Recovery from the retired employees or the employees who are
Yes,
due to
lordship.
retire within 1 year of the order of recovery.
Yes, lordship.
Okay. But I passed a judgment.
Lordship, yes,
eternal-
lordship. I
eternal
remember
rights.
lordship was, yes, lordship, on that occasion, but I was
I have
trying to.
allowed the recovery.
No, lordship, I
It's
was
a-
trying to. I was trying to do the research, however, I couldn't get a specific judgment, lordship, for that.
You ask her, you give that, give her the judgment.
Lordship, in my case, lordship, the petitioner is,
So there is no fault on your part.
yes,
And
lordship.
this contingency is not no appointment as such. Your appointment started in 1983, otherwise also.
Yes,
So there is no question of overstay.
yes, lordship.
But then be that as it may, you are saying that whether overstay, no overstay, condemnation, no condemnation, but it should be recovered in view of the judgment of the Supreme Court.
Lordship,
Para 18
correct.
plus, Roman 2.
Yes, lordship. In fact, lordship, I
Because-
have also a citation regarding the
Where is the recovery of other thing? Is there any order for recovery?
Oh, it's an annexure.
That should be the main
Yes.
Yes, lordship. I was.
impugn order.
Yes, lordship.
Where it
Annexure
is?
24, lordship, page
Huh?
44. Page 44, annexure 24, lordship.
44.
Lordship.
Yes. Can you pass a renewal order when the person is no longer in the service? Is he still alive?
No, lordship, he expired on 2020 while he was processing his pension, lordship.
2000?
2020, lordship. February, 20 February 2020,
Okay.
lordship. He
Before,
expired.
before that,
Yes. Yes.
have you received other benefits?
No, lordship, because of this matter, the pension benefit is still pending, lordship.
What is this here?
20,
Lordship,
Why you are not paying her the benefits, whatever she is entitled?
she is not entitled, your lordship.
Why?
I can satisfy this court, your lordship.
Huh.
I can satisfy this court. She is not entitled. She has actually overstayed in service for a period of 3 years.
That is what she has shown.
That is what, yeah, of course, she's saying that
But
she is not.
appointment order of the contingency is no appointment.
No, your lordship. I will satisfy my lord if,
They will continue it to.
lordship.
When you have not paid anything, how you can, why you are asking for recovery?
Lordship,
When you have not paid anything to her, why you are asking
we
for
have
recovery?
paid, your lordship, 3 years of her salary, we have paid.
What is the salary? Is
Lordship,
it comes around 14 lakhs?
yes, your lordship, after due calculation of 3 years of real estate paid salary, your lordship. We are just claiming that, no, nothing else.
He died.
Before he died, your lordship, that order was issued.
Continue to.
Lordship.
Yes.
So Lordship, in support of my submission, Lordship, I have several judgments, Lordship, if I may be allowed to furnish, Lordship.
First is
Uh,
2000.
2009 3860117, Lordship. Lordship, I have made a gist of the judgments that I'm relying on, Lordship.
Why so many?
Yes, Lordship, but I'll rely on few of them, Lordship.
Huh?
I'll be relying on few of them, Lordship. The principles are same, Lordship, in fact,
Give the latest one.
Lordship. 2000, Lordship, at number 7, Lordship,
2022.
yes, Lordship. SCC, that is also in respect to the Lordship, when there is no representation, misrepresentation on the part of the petitioner's, Lordship, and also the recovery from the retired employees is not permissible, Lordship. Also, and again 2016, Lordship, which I have also wrote in my from the pen, Lordship, point number 8, Lordship. This is also 2016, Lordship.
Also.
Yes, Lordship.
If she is over, can I submit?
Will allow.
Lordship,
She has completed her
Yes.
argument.
yes, Your Lordship.
Will allow the writ petition.
Hear me out, Your
No
Lordship.
copy.
First, hear me out, and then Your Lordship may pass any out.
Will you submit against this law laid down by the Honorable Supreme Court?
No, Your Lordship, there are also law laid down by the Honorable Supreme Court where recoveries can be made.
No, I'm not saying that it cannot be. It
Lordship.
can be made,
Yes,
but our case cannot be.
I will try to prove her wrong, Your Lordship. If I may be allowed to.
Yes.
Lordship. Lordship, my learned friend here has already read out almost all the documents, but
10 minutes, 10 minutes. I'll give you 10 minutes.
for, Your Lordship, for better understanding, allow me to take my notes from the initial appointment, Your Lordship, of the petitioner.
I've seen it. It was contingency.
Yes. Now,
Contingency for 3 years.
contingency for 3
Then
years.
fresh appointment in after 3 years.
Yes. Now, the interpreter grade 2 DB that the petitioner's husband was appointed. If you peruse the order properly, your lordship will find that the interpreter grade 2 appointment flows from the initial appointment. It is the contingency paid to us. For the fact that, your lordship, if I may be allowed to read the appointment order, that 9 February 1983,
Where it is.
page 19, annexure 2 of the writ petition.
Great position.
Yes. Your lordship, the type copy is at page 20.
Yes.
Here it says, your lordship, Sri have invoked on contingency paid DB under the establishment of subdivisional of officer civil longland is hereby appointed as interpreter grade 2 in the scale of pay. Plus all in the line compensatory allowances of basic pay subject to minimum 85 and maximum. This is the amount. This is the amount that is to be given to him. Your lordship, the first sentence itself, it says, Sri have invoked on contingency paid DB under the establishment, your lordship, under the establishment of subdivision officer Longland is hereby appointed as interpreter grade 2. So this appointment as interpreter grade 2.
When he was appointed, he was working as a contingency. It has to be referred.
Yes, so
What does it? You have not been given this appointment with effect from the date when he was allowed to serve as a contingency.
So therefore, the appointment as grade 2 interpreter flows from the initial appointment as contingency.
So unless you are paid contingency DB,
Yes.
you cannot be appointed.
Your lordship it does not say that. I'm not saying that.
If you are not saying so, what does it mean? Difference?
Your lordship, if I'm not appointed as contingency, I cannot be appointed as interpreter.
Is it a requirement?
Lordship, that's not the issue here. The issue here is whether appointment is interpreter grade 2 flows from any other initial appointment and
What are you trying to interpret? What is
it
says so, no, because he was working as a contingency. Therefore, that has been recorded.
Yes.
He is a contingency. That's what I'm saying.
Yes.
Is it meant to read that unless you are a contingency paid DB,
Lordship.
can you not be appointed as an interpreter grade 2 DB?
No, your lordship.
If not, if there was a use of reading into that,
Lordship, don't make that will be necessary, that will not be necessary. But here, the issue is overstaying on service.
overstay, when you calculate this contingent,
Yes.
only then overstay.
Your lordship.
If you don't calculate, what's the question of overstay?
Therefore, your lordship, it has to be calculated for the fact that interpreter given appointment flows from the initial appointment, your lordship, as contingency.
That's why you have released him. That is the challenge. Released him in 2015.
Yes, you.
In 2018.
Yes.
Then you have issued a release order
Yes.
subsequently,
Yes. your lordship.
posthumously,
Yes.
saying that this should have been, these 3 years could have been counted.
Correct.
We see it was not supposed to be counted. Because by reading this, it states the fact that the person who is working as a contingency is
Yes.
appointed.
Yes.
That's why I'm asking to read that, to calculate that 3 years period
Yes.
as a DB on contingency basis,
Yes.
whether the requirement of appointment
Yes.
is that a person should be work as a contingency before he is appointed as an interpreter. Is it the requirement?
Your lordship, such requirement,
If no, you cannot read into. Sorry.
Now, your lordship, the main issue of contention in this matter is
See, I just give you an example.
Lordship,
Today, you are a lawyer.
Lordship,
If you are appointed
Lordship,
in some higher or some post,
Lordship,
can you not be mentioned? Mr. So and so,
yes,
Angame,
Lordship,
learned lawyer,
Lordship,
is appointed so and so.
yes,
If you say so,
Lord.
can it mean that the post where you have been appointed,
Lordship,
that includes the period which you have worked as a lawyer will be counted?
Lordship.
That is what we are trying to
Yes,
have
my
the
lord.
same analysis.
Because Lordship, the government, there are certain government notifications which says that the period served on contract ad hoc basis has to be counted for the purpose of pensionary benefit.
No, if that is something different,
Yes.
you come to that.
Yes, that is why I'm saying election. This appointment of the clearly indicates that if the appointment has contemplated grade two, flows from the initial appointment of
It's not close.
Lordship,
The counting of his contingency or the contract
yes,
as required under the policy or not is something different.
Lordship,
Different altogether.
yes, yes.
When you say it follows from that, it's not.
Lordship.
When you say it follows, that means
Okay,
the basis of your appointment as an interpreter,
Lordship,
grade two,
Lordship.
is the contingency. That is not a requirement of the appointment.
No, Lordship, then in that case,
If you say so,
Lordship,
that is another altogether different issue.
Lordship,
That the rules or the policy says
Lordship,
the period which the person has
Yes.
as a so and so.
yes,
Because it may be fair or justified,
yes,
but when you say it follows from,
Lordship,
it's a misinterpretation, I mean misconception.
Lordship, then your Lordship, another thing that,
Simply say,
yes, yes,
if a person is appointed,
Yes.
regular or whatever this
yes,
is,
yes,
for the purpose of superannuation or the
Lordship.
retirement,
Lordship,
the period which the person has served as a contingency will be counted.
yes,
Simple.
yes, your Lordship.
Why you are trying to, I mean,
No, I was trying to come to the point, Lordship.
different, I mean, angle which confuse the court.
Your Lordship, I was trying to come to that point, your Lordship.
You come to straight
Yes,
that.
so therefore,
So there's no
there is break in service, there is no break in service.
I mean, there's no dispute that he worked as a contingency.
For a period of 3 years. Yes. So no break in service.
Whatever.
Yes,
Then he was appointed.
yes.
Maybe it is a fresh appointment, but then your rules, what is the rules or something like that?
It's a notification. Your Lordship.
Notification requires that the period which the person has served as a contingency or the
Contract or I thought.
will
Yes,
contract for the purpose of retirement.
Lordship, Lordship,
That's all.
Lordship. For the purpose of pensionary benefit. your Lordship.
Consumable.
Lordship.
What is that? What is that notification?
Lordship, I haven't brought this by your Lordship, I
Then-
can produce that, your Lordship, if your Lordship.
Not consider.
But your Lordship,
There is most important documents
yes,
which you have relied.
yes, not only that, your Lordship, there was also no break in service. I was trying to bring that to the notification of this honorable court.
What does merit that again that will require a determination that whether for the appointment as an interpreter, grade two,
Lordship,
a person need to be served as contract or contingency. If not, what is a break, no break? It doesn't make a difference.
Lordship, the issue,
Because
yes,
reason is very simple. Contingency appointment is not an appointment in the eye of law. All right,
Lordship,
I do agree so far as the requirement of notification that the contingency service, period of contingency service and whatever contract service will be counted for the purpose of personal benefits,
Lordship.
then it's okay. But when you try to say break, not break, follows this, we're not convinced.
Lordship, then in that case, allow me to place that notification.
Why you have been allowed to file an affidavit?
Therefore, your Lordship,
Other
and
than-
I fully say that.
I said,
Lordship,
other day I said, we're not doing our homework. You have filed an affidavit.
Yes.
Why you have not annexed that?
Then in that
This
case,
is a law that it need not be pleaded and it need not be annexed.
then in that case, your lordship, in my affidavit, I have clearly mentioned that there is the continuity in service. The petitioner has not given his reply. I have accepted my.
See, person has died, retired, died. You want to recover a huge amount from the widow. Have something, have some human approach.
No, your lordship, I understand that, but all these things was.
Okay, I agree that the period which the person has served on contingency basis or contract shall be counted for the purpose of personal benefit. Agree? Huh?
Lordship.
And you have allowed him to retire in 2018. Is that it?
Lordship.
Hmm?
Lordship.
Then you realize that no, it should have been counted this 3 years period of contingency. Therefore, we have to recover.
Lordship.
Which fault is this? The
Partly petitioner's fault also, your lordship. If your lordship may hear me out, I will.
Is there any fraud played by the husband of the petitioner?
Lordship, it's not about fraud. What happened was, your lordship? What happened was, your lordship? Yes. Your lordship,
Why am I trying to, find fault on him?
I'm not trying to find fault. I'm just bringing the facts before this honorable court, your lordship.
No, you have to find fault to recover.
No, because my document says so. I'm not trying to find fault. My document says so, your lordship.
Telling you.
Lordship.
I'm talking about the government.
Lordship.
The authority is not as a Angami.
No, I understand that, my lord.
Person, you are representing the government.
Lordship, therefore, I'm just reading out my own letter, your lordship, the letter. Which says that what happened was, your lordship, the petitioner was initially appointed in a particular district, then retired in another district. And therefore, his initial appointment was not available in the place where he retired. And that is clearly mentioned in our letter, your lordship.
So whose fault is?
Your lordship,
You have to find fault.
no, your lordship, I'm not finding fault.
No, you have to. If you want to recover, it's because of the fault of the petitioner,
Lordship,
misrepresentation,
lordship,
or the fraud played by the husband of the petitioner
lordship,
or the employee,
lordship.
then you can.
Yes,
If it is not the fault of the petitioner, that too after the retirement,
lordship.
I'm not saying so. It's by
Yes.
the Supreme Court.
Yes.
You can.
Yes. What happened is, your lordship,
That person has died.
yes. What happened, your lordship,
It's
is,
about the retirement.
yes. What happened, your lordship, is there was a contribution made by the petitioner also in staying in the service.
To that contributory.
Yes. I'm not putting the entirely on the, yes, not on the petitioner, your lordship. Your lordship, what happened was,
It's been 10 minutes.
Your lordship, what happened was after the verifications from the office of the commissioner was sent to the deputy commissioner. This is the place where we retired. Now, the petitioner was appointed under the deputy commissioner Tunsang. Under the deputy commissioner Tunsang, and he retires under the deputy commissioner Mendang. So the pension paper was processed to the commissioner's office, your lordship. And the commissioner's office has sought clarifications with regard to his initial appointment order, your lordship. Now, the deputy commissioner, your lordship, has in his reply to the letter of the commissioner, has clearly stated that because there was no report available in the office of the deputy commissioner, this is the reason why, your lordship, it has made an overstay in service for a period of 3 years. This is clearly mentioned.
If the record is not available.
Yes.
Is it the fault of the employee?
No. What happened is because you see, your lordship, we did not have the request, so we have mentioned officers. There is a mistake of the your lordship. But your lordship, the petitioner has annexed the initial appointment order in the petition. Remember that he has it. The petitioner has his initial appointment order. But the petitioner only needs to the date and the year. It's supposed to return, your lordship.
Where is the notification?
Lordship.
Notification of which year? Notification of which year, where it says the period of contingency of the contract will be counted for the purpose of.
Lordship, if your lordship can give me 2 minutes, in a contingent issued by the P&R department, your lordship, it is there.
Which year?
Lordship, I am not very sure about the year, but I think if the contingent is here,
Yes.
I can take it and show to my lordship.
You find out. You find out later, but you make your other submission.
Lordship. Shall I submit, lordship?
Yes,
Lordship.
you saw that which year it was issued.
Lordship, I will submit it, lordship. Thereafter, your lordship, what happened was, since the department or department does not have the authority to condemn the oversight period, it was sent before the P&R department for condemnation, your lordship. My lordship have already seen that the P&R department agrees to condemn the oversight period, but there was a condition prescribed, your lordship. And the condition was that the oversight period shall not be counted for defined length of pension, and the analysis available in the same period of oversight service shall be treated as honorarium, and no recovery shall be made. But this fee is subject to the approval of the cabinet. Now, also what happened is that it was a cabinet member was prepared after the PNR has issued this letter. And in the cabinet member, everything that the PNR has said is mentioned. The cabinet declined to do the same, your lordship. Now, your lordship, the cabinet in fact has rightly declined to condemn the oversight period. I'll explain.
Obviously, you will say so.
I'll explain, your lordship.
Will argue against his own case.
Your lordship, I'll explain, your lordship, what happened. Your lordship, from the date of his initial appointment, the petitioner was supposed to retire in 2015, as your lordship has already seen it. But because of his overstaying period of 3 years, he was going to retire in the year 2018. Now, between 3 years of overstay period, your lordship, a promotion was randomly given to the petitioner. If I may be allowed to take my lordship to that particular promotion order, your lordship. Your lordship, the promotion order, your lordship will find that page 24.
It's okay. You saw us. Again, I'm repeating. Whose fault the employee was allowed to overstay for 2 years? Is it a false, misrepresentation or fraud played by the employee?
No.
Then
no.
You show us.
However, your lordship, as I pointed out, what happened was because the person did not retire in the same under the same office. Not only that, but not under the same district as well. And therefore, it has because initial appointment was not available in the district where he has retired. That is the reason why he was made to overstay. That is the mistake we have committed. But here the petitioner also have the initial appointment order with him.
That's why he may not know a DB or something like that, grade 2, grade 4. That under the law, contingency is no appointment. Contingency appointment is no appointment at all. So why should you bother?
Your lordship, I don't want to.
It's regularly appointed.
Yes, I don't want to argue on another subject matter. However, the lordship contingency paid employees are also given a minimum scale of pay.
Are you sure?
Your lordship, in certain
Are you
sure? Lordship.
Has he been given? Has he been given minimum scale of pay?
No. So that's why I said I don't want to argue on another issue.
I would like to know. Enlighten us.
Your lordship knows better than me. I would not like to argue on that subject, but what I was trying to say was
frankly,
yes.
I don't know.
Yes.
You don't know anything.
Yes. Your lordship knows better, but your lordship, I was not on that issue. Here, I just wanted to project that there was a
representing a state.
Yes,
making a statement that the contingencies are being paid at the scale of pay. We are dealing with every day.
Lordship.
Claiming for a scale of pay.
Lordship.
Audio submission will record it and will direct the government.
Lordship,
This is the government.
In fact-
Spokesperson, I mean, and lawyer, counsel for the government
Yes.
that is making a submission in the, court. So why should unnecessarily spend our time to determine whether they're entitled, not entitled? So some of them are given, you give all of them.
the Lordship, there, here the petitioner is just seeking about the minimum scale. I'm just trying to bring the contingent employees in between, Your
Yes.
Lordship. It's just that, I'm talking about their rights.
What I know is, what this court knows is appointment on contingency is no appointment in the eyes of law.
Lordship. I'll keep that in mind, Your Lordship. However, Your Lordship, what I was just trying to show was the period that the contingency that the her petitioner husband has served has to be calculated because there was no break whatsoever in the service. And also in the appointment order where he was appointed as interpreter grade 2, it clearly says that the petitioner's husband contingent employees.
Of course,
Yes,
he was working
yes.
as on contingency basis.
So it flows from there.
It is bound to,
It flows from there. Now, Your Lordship,
just mentioning it, it will not give, leverage to you. That is follows from that.
yes, Your Lordship, I will try
And
to submit the notifications.
If your notification requires that it has to be counted,
Yes,
that this court may agree with you, but not that it follows from that because he is also to be counted and all those things.
Lordship, Lordship, Lordship.
Anyway, issue is whether you can,
Yes,
Recover
whether we can
or not.
recover on that.
that's all.
Yes, Your Lordship. In that case, Your
So
Lordship,
according to her, she has very simple, as per the Supreme Court judgment, once retired, you cannot recover.
yes, Your
But
Lordship,
there is no fault or misrepresentation or the fraud fled by the employee.
yes,
That is the, you answer to that.
yes, Your Lordship. Then in that case, Your Lordship, allow me to raise a citation 2012 8 SCC 417.
Yes, you give the such. 2012,
8 SCC
yes,
417.
417.
Your Lordship. Paragraph 14.
Name of the parties,
Name of the parties is Your Lordship, Chandri Prasad Ulyan and others. Chandri Prasad Ulyan and others. Versus State of Uttarakhand and others. The relevant portion, Your Lordship, is at page 43, paragraph 14. Page 423, Your Lordship, I beg my Lordship apology.
page,
423,
yes,
paragraph 14.
yes,
If I may be allowed to read.
yes, yes.
We are concerned with the excess payment of public money, which is often described as a taxpayer money, which belongs neither to the officers who have affected overpayment nor to the recipients. We fail to see that the concept of fraud or misrepresentation is being in such situations. The question to be asked is whether excess money has been paid or not. We need to verify respect. Presumably, affecting excess payment of public money by the officers may be due to various reasons like negligence, carelessness, conditions, favoritism, etc. Because in such situation does not belong to the payer of the money. Situations may also arise that they depend on fraud. Then the mistake is mutual. Payments are being affected in many situations without any authority of law, and payments are being received by the recipients also without any authority of law. Any amount of payment received without the authority of law can always be recovered by a few exceptions of extreme hardship, but not as a matter of rights. In such situations, we some obligations on the people to repay the money, otherwise it would amount to unjust enrichment.
Yes. What's the matter? Facts of the matter here?
Lordship, the facts of the matters here, Lordship, is about excess salary paid to the appellant due to irregular wrong fixation
Yes.
of pay.
But this is not the case. For these 3 years overstay,
Yes,
he worked for the state.
Lordship,
He has served for 2 years,
Lordship,
isn't it?
Lordship.
wrong fixation. If we excess payment, it's not an excess payment.
Lordship,
It's an overstay where you have to pay him. So there's a difference.
here, your lordship, wrong pay fixation is done because of a wrong promotion given to him.
For 3 years.
Yes, my lord. That is why.
Are you only recovering the 3 years salary or
Yes.
the excess payment of wrong promotion? This is wrong promotion.
Only the excess payment of 3 years, your lordship, it is there in the order.
Not the excess payment for which he was wrongly promoted.
No, your lordship, by a first release order, because the cabinet has declined to condone the same. So by a new release order, your lordship, the wrong promotion that was given to him was reverted back. And the amount was paid to him during the wrong, this thing,
After his retirement.
lordship.
After his retirement, you have reverted him back. You have brought him 3 years back. 3 years in advance. After retirement.
After retirement, your lordship.
Had it been during his service time, service life, that would have been different.
I agree, your lordship. I agree.
That's the reason Supreme Court says after retirement, no recovery.
Yes. The only issue that of concern, your lordship, is if it was not condoned, then the wrong promotion that was given to the petitioner will remain. And therefore, the petitioner will be allowed to draw an illegal pension, your lordship.
It's derived from your overstay only.
But if the petitioner here is claiming that she is not going to go for that wrong promotion given to her husband, in that case, your lordship, I leave it to my lord. Because that is what they have stated in the writ petition, your lordship, that they are not claiming.
They are not claiming.
Yes, lordship, we are in fact agreed
What
by
you have
the
stated?
release order. Yes, lordship, that is why.
What you have stated.
Para 32, your lordship.
Yes. So you will claim only not as a what is called?
Excess recovery, lordship. Lordship, here the petitioner is aggrieved only against a recovery, lordship.
No,
Not,
everything will have to be, it's connected, no? You just can isolately.
Yes.
You may be agreed by recovery,
lordship,
but to whether it should be recovered, not recovered, it has to be, everything is connected.
lordship.
Unless the husband overstayed, no question of recovery or no question of promotion.
Lordship.
How much amount will come down?
Lordship,
If
yes, the entire amount will be rupees 14 lakhs, 90,273, your lordship. This is the excess salary paid to the petitioner's husband for overstay period of 3 years.
3 years only,
Yes.
as a what? As a PA or as a
PA to DC, lordship.
PA to DC when you were promoted?
2016, lordship.
8 September 2016, your lordship.
Yes.
We can go like that.
I'm referring for the Office of the Accountant General. Basing on the calculation made by the state respondent lordship, we have written a letter to the Deputy Commissioner of Longland. May kindly come to annexure 27, page 48 of the writ petition, Lordship.
48.
Yes, this will clarify the amount. The calculation may be set annexure 24A, Lordship, which your Lordship has seen. Lordship, we come to page 48, annexure 27.
Yes.
This letter of the Office of the Principal Accountant General, Lordship, to the Deputy Commissioner, this letter dated 10th of September 2020. Subject pension, family pension case in respect of Sri Hamvok beyond retired special grade Debashi. In writing a reference to your letter number so dated 11/6/2020, I am to return the service book in respect of Sri Hamvok form retired special grade Debashi. As per letter, it is ordered that the excess drawal of pay and allowances amounting to Rs 14,90,273 to be recovered from his pension gratuity. However, his pension gratuity is calculated at 5,78,490 only. Therefore, further course of action in this regard may be intimated early for settlement of pension. So we have already written, and the basis of the calculation made by the state. Calculation the state has already explained how excess has been paid, Lordship. So we have just reiterated the letter of the state respondent, Lordship. So we ask for a clarification from that. That's how the AG has come into picture, Lordship.
No, the amount to be recovered is 14 lakhs.
Yes, Lordship.
But then his pension gratuity is 5 lakhs.
5 lakhs.
What do you mean by this?
Lordship.
What do you mean by this?
Because whatever he has earned, the pension gratuity he has earned, Lordship, that is 5 lakhs. So the amount does not tally. Because we have to enter the pension book, Lordship, in a PPO. We have to authenticate it. This is a calculation. We are just authenticating a body, Lordship. So the amount does not tally. Recovery is 14 lakhs, pension gratuity is 5 lakhs only. So there's a vast difference in the amount. Because as per the calculation given by the state respondent, Lordship.
Why this is, how you recover?
Lordship,
They said it's 5,78,000.
yes, now your Lordship, that's
You said 14 lakhs.
14 lakhs, your Lordship is
Why there's a difference?
yes, total amount to be recovered.
Ah,
And as far
3 years of yes.
as per the pension gratuity, the retired pensioner has only 5 lakhs in
so you want that excess, this minus,
it comes around 9 lakhs, almost 9 lakhs.
9 lakhs has to be recorded from the widow.
Your Lordship,
If he's entitled, this entitlement is 5 lakhs something, another 9 lakhs something,
Lordship,
say 8 lakhs.
yes.
Has to be recovered from the widow.
Lordship, if my learned friend and the petitioner as well as the state respondent, they are saying that a wrong promotion was given in year 2016. Then as per the calculation of the state respondent, Lordship, though I have not found an affidavit because like this is before us, so Lordship, the annexure 24A, the calculated amount, Lordship, the affected
Which one?
page 49, 45, Lordship.
Yes.
Page 45. Promotion date. 8th September 2016 is the promotion of the petitioner, late husband, Lordship. So the amount to be recovered, Lordship, as per the calculation, it should come from six line. September, July.
9.
Oh, nine. Then 1, 2, 3, 4, 5, 6, 7. Last 4 from below, Lordship. The effective date of promotion is 8th September, Lordship.
Where is 8 September? There's no 8 September.
No, Lordship, the promotion, I'm relying on page 24 of the petition, the promotion of the late petitioner's husband. So the recovery has to be from here.
One,
Yes,
1 second.
1st September 2016. So we have sought for justification of that. Because the amount shown by them is 14 lakhs. But what we have written letter to the
Your calculation is
Yes,
15.
since they are saying from the date of the illegal promotion that was given. When he was supposed to retire, they are given a promotion. So promotion date is from 1st September 2019. So as per the calculation, it should be from, the recovery should be from 1st September 2016 till the day his release order was issued. So we have sought for clarification from them. His pension gratuity is only 5,78,000. But you are saying the whole recovery is 14 lakhs.
No pension, nothing. You have not received anything.
No, Lordship.
Your lordship, if I may be allowed to explain this.
So you will not ask for a further pension.
Lordship, we are not seeking for the 3 years, Lordship. If it's the writing, in fact, Lordship, the petitioner is saying if it's the writing
not
to
seeking it,
yes, Lordship.
But
But only for the
besides
recovery.
that, if there is anything to be paid, they have to pay.
Yet for the great, for the special great Lordship. But recovery, that is, he has already performed his duties, Lordship. And that is the salary that is given to him for the duties that is performed, Lordship. And in fact, Lordship, regarding the condemnation, like in the first place, only the petitioner has never seek for the condemnation of the age, Lordship. She is aggrieved only for the duties that the salaries that has been given to her has been for the duties that he has performed, Lordship. And in fact, regarding the submission made by the learned counsel, Lordship, the citation which he has relied on, Lordship, here they were in service.
Have you
Lordship.
complete? Tomorrow you will not enlist me that what has not heard me.
Lordship, in this judgment, they were still in service, Lordship, and recoveries will make, if my Lord may kindly appreciate the para.
It's okay, it's okay.
Lordship.
So
Suppose I have not taken I have not decided the matter as yet. Suppose if court allows your writ petition, will you ask for further benefits which may?
No,
like,
Lordship.
you
It's
will not
not
ask
said in
anything.
our petition.
You will not
Lordship.
ask anything.
Yes, sir, Lordship, for the special great Lordship, till
You
special.
will not
great-
ask anything,
No, Lordship, she's not asking for that.
except if there is
Recoveries.
no recovery, you
Lordship,
will not ask anything.
Lordship, it's
Your
not said in our
husband has
petition.
died.
Yes, Lordship.
Can we record that?
Lordship, yes, Lordship. It's clearly stated in our petition.
No recovery.
Paragraph 32, they are written.
Yes.
No, but this is the suggestion she has given. If it is right thing to do so,
Lordship, it's clearly
you
written.
read the language.
Lordship,
If this court finds that this is not the right thing to do so, she may
if she
ready to ask for that.
If she considers that, we have nothing to say about it.
But she said, you said read that thing, no?
Yes, but as far
If
as
it is the right thing to
yes,
do so.
but as far as the charge is concerned, since the state is strongly banking on that submission, that the wrong promotion was given, that recovery part should be there. That's how we have written to the back to the government.
So prima facie, I'll pass the order,
Lordship.
no recovery. No, I'll go through your affidavit as well as your
Yes.
judgment. She has given so many judgment.
Lordship,
Had he relied only one judgment, I would have dictated right now. But since he has given so many judgment,
Lordship.
and you have given one judgment saying that it can be recovered. None should be given, given the unjust enrichment.
Lordship.
I'll consider it.
Lordship.
But prima facie, no recovery.
Lordship, if she is not claiming the other benefits, your Lordship,
I'll say, we'll determine on the basis of the law and your submission. All right. And Ms. So-and-so, learned counsel for the petitioner. And also her Enangami,
Lordship.
learned counsel for the state respondent. For respondent number 6. You have nothing much to,
Five.
respondent number 5. You don't have to,
Nothing as much, but since our letter has been brought to the notice of court.
according to you, these are the discrepancies,
Yes.
differences, according to your calculation, this is this much. Therefore, we have written it to.
Yes.
So anyway, that is in between you and
Yes.
Lordship, if I may be allowed to express one concern, your Lordship.
yes.
If the cabinet decision is condoned, or it's being quashed and set aside, Then your lordship.
No, we're not setting aside any cabinet decision. We're setting aside the order of recovery as well as the whatever impugn. Not cabinet decision as such.
Lordship,
Not cabinet decision as such.
lordship.
The orders which we have given to her for recovery, that will be set aside. In case,
In case.
I'm not keeping it CAB,
Yes.
I'll pass the order.
Okay, lordship.
Hmm.
I am deeply obliged, my lord.
Much obliged.
You don't do that. This over, whatever the one more item. Yes. This. Yes. Sir, this is a writ petition. Where is there urgency is there?
My lord, because tomorrow will be Wednesday again.
Huh?
Tomorrow is Wednesday again. I cannot move tomorrow again.
Day after?
Day after, Lord, there's urgency.
No, it can be listed before court number 1. Because practice, we have discussed, let us be very frank. Practice is not a rule or, I mean,
Yes.
law as such.
No.
That's why I had a reservation, so morning I asked you. You are also correct that there is no
There's
rule
no
or
bar, no bar.
no bar, but then practice and the propriety of the practice demands that writ petition should be mentioned and listed before the court number 1. So why should make these things upside down? You may mention in the morning.
Lordship, this morning I will have a thought, but this morning there were a few hearing matters, so I thought that.
Because I have discussed with him,
Yes,
you know, we have to function everywhere. It has to be transparency is with there. So on discussion, we have decided that the normal practice which is on, I mean, in vogue, will have to go by that. So writ petition, unless it is to be listed before it, or it is automatically listed, mention should be before the court number 1. I agree, there is no bar. Court number 2 or court number 1. There is no distinction as such under the law. The practice, we just cannot make it upset down, upset. All right. So if there is no involvement of personal liberty of a person, can you will direct it the list before the court number 1?
the difficulties.
And then in view of that, can be taken up after the division bench is over tomorrow, if there is a urgency.
I think Lordship sees page 20 urgency, page 20 urgency. I have that burden I have in my mind. Page 20 advertisement.
20.
Yes,
Yes. What is it says?
clause 4. Last day for online submission of 8/22/2023. That's the only trouble I have. Because my junior, they filed yesterday, but according to the registry, it came only around 4. In fact, the court functioning hour was up to
Today is 19th.
today's 19.
Take up tomorrow. You may mention in the chamber also before the court number 1.
Because yesterday,
Because you see, even if there is a division bench, if there is a urgency, you can make a mention always. Because I don't want to make the things
I
upset.
agree, I understand, Mr. Michael.
In fact, I have discussed with, as discussed with my,
Registry, if
I have discussed with my brother also.
occasionally, if registry can be reminded, because when we file around 4, when the court business hour is 4:30, sometimes I think they should accommodate us also. Because during the working hour, when we file, then they don't list it. So we have an
But,
in
sir,
case urgency like this.
Sir, there is a difficulty in the registry also.
I appreciate that also. I understand that also.
That's why in some benches, they don't receive it after 2.
That's why I thought that Lordship will think that I'm trying to, I pray for two, so that Lordship will also go through that, so that I should not
No,
hide.
no, to take up the matter is not an issue, but as a normal practice of the bench. So I don't want. My brother will also know, there's no bar, he'll not be, I mean, say that why not this, it's not that. But the
appreciate.
practice which we have been following, so I don't want to make it upset.
I appreciate about that.
So we'll direct it list before the court number 1 tomorrow.
Trouble was, BB is tomorrow, it's not listed today, I was just calling them, you should.
Maybe though, I think most probably we get over by.
My lord, no problem. If that is difficult, no problem. I mean,
Others have no issue taking up the matter. You have seen, we have taken up the matter. But this is something which I had a reservation since morning. And in fact, I have discussed with my brother. So he doesn't have any objection, but then the practice is, we have to allow the practice to remain.
I was, as it this morning, few hearings, so I thought, went up abruptly like.
Had it been civil, I mean, criminal or civil, no
I
issue.
understand.
Writ petition,
I agree.
there is a understanding of allotment of the thing. All right. Mr. Ajo, Learned Counsel for the petitioners. List this matter on 20/01/2022 before the court number 1.
Yes,
You may make a mention in the morning.
my lord.
Well, in the chamber also. You cannot obviously mention when you are sitting in division
If
bench.
there is no.
No, in that case, I'll just say, I'll not say code number 1. I'll say list the method on 29/2021. The registry also, since it has already been filed, there's a urgency. Either of the court they may.
That is the only problem I have.
And I'll tell the brother that since it was a writ petition, so I did not take up. It should be placed before you.
What?
Then I say I have passed an order that this matter be listed on 20th so and so. Whoever courts.
Much.
My lord,
Yes.
this case is taken up by the principal counsel as Jata. But the principal counsel is not able to come for this consecutive days. And it seems the honorable court wise and feel that just want to dispose of the matter.
No, I am not. Not honorable court. This
Actually-
is a 2017 matter.
Yes, Your Honor. So I convey the fact of the decision, and then my senior, the principal counsel said that, so if all this, so I may be allowed. I wish that if my principal counsel comes and give the satisfaction, the submission, then it will be very satisfied. But still then, since the matter is such a nature that it is very dragging, lengthy, and then just want to dispose. I have nothing to say, but only the things what we have already bring down in the petition. That's much what I would like to submit before this honorable court. That's what, this is the case that the state has taken the indigenous issue for Rongmei community who has been living.
So you want to argue the matter, or you want that your senior should appear?
You know, if allowed, I may be allowed to just proceed the hearing.
Huh?
Allowed to proceed for hearing.
That is what I pray for.
Yes.
This is the case that I have stated. This has been dragging since for a long time, and then recently in 2007, the state government has taken the step and they have constituted committee. And it took 5 years to come to the conclusion for the recognition of indigenous people of this particular 1,330 community, only those members. That government has taken 5 years and then 12 rounds of meeting within 5 years. And then on 4th August 2012, the government has already consulted and government has already allowed those who were enrolled in 1963 in the first election. So they have already notified the other legitimate indigenous peoples and they entitled to enjoy all the tribes and the indigenous facilities. So after 2012, the government has taken the state notification, all the posting, the functioning was there. And then in 2017, after 5 years of the recognition and the procedure of the implementation, the new chief minister, new government formed here. After they have all about the 5 years that they have withdrawn the one prayer. The recognition was 2012 was that in disease as well as a tribe. In 2017, they have taken the attack of the tribes. So that was the contention of the case. That 2017, they have withdrawn. So that withdrawn impugns notification is challenging by the this council, this only council. Here, Your Honor, the brief of the case, I just beg your pardon, just I draw your attention just for patient hearing while I'm just going through my petition. I'll not go for further investigation since the matter is very clear. The challenging the impugns or when you look at notification of 2017 by the cabinet, that is only my intention challenging to.
You saw the impugn order?
Your Honor, the impugn orders is case number 45.
Who are the respondents here? Just wait, huh? Just wait.
Yes, sir.
Just a minute. Respondent 1, 2, 3.
That's all yours. 1 to 3.
You are for 1, 2, 3.
Yes, Your Lordship.
And 4 is 4 and 5.
Your Honor, 1, 4 is already they have withdrawn. They have already withdrawn the respondent 4. And now number 5 is coming from the community. That's only supporting to my prayer that they should not hurt me.
You are for respondent number 5.
5 Lords.
4 has withdrawn.
Yes, Your Honor.
By which order? Impleted. No, it has been impleted only. No withdrawn.
Yes, they impleted and they were contesting. And then finally they come to the realization that there is no issue, there is no consensus.
So they have withdrawn.
Yes.
By which order?
Yes.
By which order? By which order?
That is their petition.
Where is
That is
this?
different.
Yeah.
Your Lordship, by order dated 23rd, 10, 2018,
They were implemented.
REA
Yes.
C41K 2018,
Yes.
the PO was impleted as
Yes.
R4.
Yes.
Yes.
Not withdrawn. They have implemented themselves.
Yes.
Not withdrawn.
But nobody is representing them.
No.
So. Come to, please show me the impugn order.
Yes, Your Honor, the case number.
Other petition which was filed by the PO was withdrawn. Other than that, they got themselves impleted.
Okay.
as R4.
They have filed a writ petition.
Yes,
Withdrawn.
earlier.
Earlier.
Yes, your lordship.
So that is going to
That
withdraw.
is withdrawn.
Against here.
The court implemented.
Okay.
Yes, your lordship.
So if they themselves implemented,
Yes, your lordship.
and after implementing, if you are not appearing, what to do? It's okay. Yes.
Your the impugns or notification order is reflecting in the annexure K, that is page number 48 in my petition.
48.
Yes, sir.
Okay.
Your Honor, in that annexure K, page 48. Here in pursuant of the decision
Yes.
of the cabinet in the meeting held on 25th April 2017. The recognition of Rongmei tribe as one of the indigenous Naga tribe of Nagaland as notified by the government-wide notification number such dated 4 August 12 is hereby withdrawn with immediate effect. And para 2, the 1,313 people belong to Rongmei tribe already identified by the government of Nagaland through special enumeration process as having permanently resettled in the present territory of Nagaland prior to 1/01/12/96, along with their legitimate descendants, would continue to enjoy the status, privilege, and entitlement of indigenous inhabitants of Nagaland, similar to the ones being enjoyed by members of other indigenous inhabitants who had permanently settled in the present territory of Nagaland prior to 01/12/96 as notified by the state government by notification number APPT 16/6/67 dated 06/07/1973 and number AR A/A/76 dated 28/04/1977. This issue is suppression of the petition number 4 August. That is the notification which they have withdrawn. So this is unconstitutional. This is the impugned notification. You know why we are contesting, why we are filing this? Because they fail to see the sequence of the government policy. Now, Your Honor, the government has own process for the withdrawal also. That is already the state, they have constituted members in 2014. You know, in this 2014, the government has made a memorandum in page number 42, the annexure H. Their state government has given one notification, constituted body to go through and to re-verify if there is any to withdraw or to nullify. In that committee, there are 4 and 9 committee members are there. So while this 9 constituted body members were not given the opinions, fact findings of the issues of the bill. So the cabinet decision, which is very whimsy and it is very sudden, where the business of the legislature assembly was not maintained. Why? In the report, yes, Your Honor, in page 42, government has constituted a member committee for.
Where's the constitutional order?
Yes, Your Honor, here.
Come to constitutional order.
Yes, Your Honor, case number 42, annexure H.
42.
Yes, Your Honor.
No, this is minus of the meeting.
Yes, this is the.
No, no, when the constitutional order,
The constitutional order.
presidential order. 1950 and thereafter. Any amendment has been made after
No.
1950,
No, Your Honor, after.
1970. What is your constitutional order?
Your Honor, there is no such. Now, Your Honor, what?
Page 23, there is.
Your Honor, yes, this is the tribe definition and the constitution of Nagaland. Now I'm talking about the withdrawals, particular to those 1,313. The government has already consented and allowed.
Are you- Under this constitutional order, are you a tribe? Scheduled tribe in the state of the Nagaland?
Yes, Your Honor.
Where?
So the.
Where it is?
That is the
Where it is?
1971 order.
Of the president?
Yeah, that is presuming that the government of Nagaland has already consented. That means those who are living in the state since 63.
Anyway, 2012 by the state government
Yes,
includes you as a scheduled tribe
yes.
of the state.
Yeah.
Thereafter in 2018, what is the interim order?
Yes,
17.
Yes,
The by a cabinet decision that has been withdrawn.
yes, Your Honor.
So now issue is whether you are scheduled tribe of Nagaland
Yes,
or
Your Honor.
not, that will be by the parliament.
Yes, Your Honor.
You may approach the government, government may send it for whether you are a scheduled tribe or not, that is be sent it to the parliament.
Yes,
Parliament has to amend the constitutional order, including your name, a tribe, as a scheduled tribe of the state. And then accordingly, the order will be issued. Unless that is done, the amendment is done. Either not the state government or the court has no authority to declare you a scheduled tribe of a particular state.
yes, Your Honor.
We do understand you are a scheduled tribe. I am a scheduled tribe. But scheduled tribe doesn't mean that you have to have a, you have to be the scheduled tribe of a particular state. And accordingly, if you are a scheduled tribe of a particular state, that has to be included by act of the parliament under Article 342 of the Constitution. And accordingly, notification will be issued. Then you become the scheduled tribe of that particular state. Unless that is done, as I said, now the government or the court has nothing to do with it.
Your Honor.
Inclusion, deletion, everything.
Your Honor.
If you can show that you are the scheduled tribe of the Nagaland, as per the constitutional order issued under the Article T42, then if the government says that no, you cannot be a scheduled tribe of Nagaland, in that case, we may look into. If you are for seeking inclusion, you have to approach the appropriate authority, and that will be decided by the act of parliament only under the Article 342.
Yes, my lord.
So you are aware of the.
Yes, Your Honor, my lord, this is the contention what I just come before this temples of justice.
Yes.
How the state legislature misuse and violating. Now I come to.
You just show me.
Yes, yes.
As per the constitutional order, you are the scheduled tribe of the state.
Yeah, Your Honor.
Just show me.
Now, the state government has already passed in 2012. That is their.
That cannot.
Yes, Your Honor.
That's what I'm saying. First you will come to that.
Yeah, I understood it.
Definitely will hear you. We'll come to that. You just show me that the presidential order 1950 or 1970 or any amendment by the act of the parliament, you have to notify the scheduled tribe of the state. Just show me first that.
That is, Your Honor, is rule that constituted in 1970, which is reflected in Annexure A. This Naga is the tribe which is over many scheduled tribes. So that is the issue. Now, the issue of this Romai is
Naga means
Naga.
including the petitioner.
Yes,
Is it?
Your Honor. Now the
Who will interpret that?
yes, Your Honor. This is the Your Honor, maybe kind of a position. What I'm just trying to figure it out.
Yes.
The evolution of the state, Your Honor, your lordship know better. It was under Assam. And it was the particular Romai community has been living in the Dimapur since time immemorials. And then the British sir came and the Naga, all the administration started. And then they were allowed to live. They don't buy anything land from the government. They don't buy any from Nagaland state.
Sir,
It is, Your Honor,
for a moment, I'm not saying this court is not saying that you are not a tribe of Nagaland or not. I'm not saying that you are not a scheduled tribe of Nagaland. Neither I'm saying that you are a scheduled tribe of Nagaland.
yes, Your Honor.
What I'm saying is, this court is saying is, the court or the state government has no authority to declare the particular tribe is as tribe of the particular state.
Yes,
It is the act of the parliament
yes,
will decide.
yes. You're not the same thing. The state.
So
is-
suppose if you are not a scheduled tribe of a particular state, if the government includes you, that is also not permissible. If you are as per the constitutional order, if you are a scheduled tribe under the constitutional order, if the government deletes you, that is also not permissible. For addition and deletion, if it has state to be added by the parliament, it has to be deleted, it is by the parliament. So unless you show that as per the constitutional order, the petitioners are the bona fide scheduled tribe of Nagaland, as per the constitution of India, a notification issued thereon, cannot do anything.
Now, Your Honor, just for the discussion.
I understand what you are
Now,
trying to say is
suppose-
this Nagaland, this tribe petitioner,
Dimapur,
Nagara means includes the petition, tribe of petitioner, that is what you are trying to.
yes, now the Dimapur was the indigenous people live. And when the Naga, Romai Naga indigenous people march this Dimapur Nagaland, then they are rejected, they are not tribals. Is it the law? This is what the contention comes.
No,
Therefore, Your Honor,
what you are saying, what you have submitted? Just repeat.
yes, suppose this Dimapur in the olden day, people are living together as indigenous. And then when the Nagaland state 1963 comes,
Yes,
that's become the Nagaland state. And when the Romai people are indigenous in the time of Assam, they are indigenous and enjoy it. But when the state comes and they are bifurcated, they are not belong to this state. So this is not fair.
no,
Therefore-
that may not be fair.
Yeah,
What this court is on is you may be certain tribe of this Nagaland, or for that matter, any state, unless you are recognized as per the Constitution of India by the Act of Parliament and the notification issued thereafter, this court or the state government cannot do anything. They don't have any authority to declare either this court or this state government, either they cannot say add or delete. That's why I'm saying you just show us if you are claiming that as per the constitutional order, I am also a scheduled tribe of the state. Show me that first.
Yes, Your Honor, that was known as Kabui and the Kachanaga to the particular community from the southern side.
Hmm.
So in 2000, 12, that the amendment act of the Constitution Ministry of Law, this is case number 49.
49.
Yes, it is already amended. This act called Constitution Amendment, Civil Tribe Amendment Act 2011. That is case 49.
Where it is?
That is in the
Page 49.
49, the Paratu, in schedule of the Constitution, right, 1950 or
Yes.
1950. A part 10 Manipur for entry and substituted in Kabui Impui Romai. And this entry was bifurcated this in 2012. Order number 2, 8 January 2012. So this is the name.
It's for Manipur.
Your Honor.
It's for Manipur.
That is
Where is Nagaland?
Nagaland is.
You are from Nagaland?
Yes, Nagaland is.
See, Arunachal also, this next page. Arunachal Pradesh for entry for substitute Galo. I'm a Galo tribe. I'm a Galo tribe.
Yeah.
It has to be done like this.
Yeah, Your Honor. Yeah.
Unless it is done.
Yes, Your Honor.
Let the state government
Your Honor.
does this. This is by the.
Yes, yes. Therefore, now the issue has come to the Nagaland legislature. And the Nagaland legislature has 5 years taken round tables, and they have come to the conclusion. Yes, they are very much things belong to Nagaland. Therefore, they have permitted. So when the final status come up, government has constituted, the state government has constituted member. And then the report is yet to come. This is the business which is accommodated by the state government after several years. So in page number 49.
49 is an amendment.
Yes.
This is the proper process.
Yeah, Your Honor, I just want to read the page
Yes.
46. Cabinet memo. This is the memo says. So now, in order to save time, I'll just go to the particulars page number 47. The report says in para number 2, present status. Just before withdrawing of this induced notification, this is the report of the constituted by the state. Here it says the present status. The decision of the cabinet dated 23/7/2012 and the subsequent notification dated 04/08/2012. Herein, Romai has been recognized as one of the Nama tribe with certain laid down condition for issuance of the Sioux tribe certificate and indigenous tribe certificate. Has not undergone any change of modification. Number 3. And 2.2. The report recommendation from the committee under the chairmanship of the chief secretary and the subsequent cabinet subcommittee as mentioned in paragraph 4 and 5 above are still awaited.
It's a cabinet note.
Yes, this is cabinet note. Now, Your Honor, when you go to the annexure K14, the report has already said, yes, it has already said that still awaited. Report is not yet to the place to the table of the cabinet. So they have taken this as a additional agenda and they pass. Therefore, the contention of this issue is that legislature has passed without taking the consideration of the cabinet constituted members. Now the order is awaited. Suppose when the constituted body, when the search and the research, when the analysis group say, yes, we can omit or we can delete, that is the issue. But before coming to the screening, so the political motivation has come in sudden additional agenda. And the business of the legislature, so under Article 166, there should be information for the discussion in the cabinet. So it was not taken. It was very sudden and issue. So this is illegal. It is violating the right. If so, they have to depend on the committee which constituted, where they're waiting for the outcome of the things. Outcome of the committee.
You're impressed about the government?
Your Honor, that's I pray to this honorable court that
Have you understood what this court has pointed out? What is the review or the judicial review power of this court in such a matter? I said neither the state government nor the court has any authority to decide such matter. The process, for a moment, neither I'm saying nor I'm not saying you are not a tribe, scheduled tribe, or for that matter, not the scheduled tribe of Nagaland. But the constitutional order for the state of Nagaland, by the Act of Parliament under 342, doesn't show your name of the tribe. So if it is a scheduled tribe of the state, you have to approach the appropriate authority for inclusion or deletion. So like which you have shown, page 49, in the case of Manipur, there was an amendment where the Ramai has been included. And next page, my tribe, Galo, has been substituted because it was wrongly written as in the constitutional order. Scheduled tribe order, it says Galong, G-A-L-O-N-G. So N-G was omitted. For omission of that wrong, two letter also, it has to go the amendment process in the parliament. And it took so many years. So this is, the court cannot interfere in such a matter.
Your Honor,
that is which it is, you have rightly annexed this constitutional amendment order. This is of
1970.
No, 2012.
12 is
Yes. This, I'll just share you. This, we started in somewhere in 95. Somewhere in 1995, we started that this, our tribe, name of our tribe has been wrongly been given as the NG should not be there. We started in 1995, ultimately is amended in 2012 by the Act of Parliament. And Parliament is the authority by under Article 342. So for deletion of one, this wrong, the two letters, it takes time, and the process is there. So I should not advise this court. Of course, will determine that these are the issues this court is handicapped. And for that matter, state authority, state government has also no authority to decide the matter, whether you are a secretary of the state or not.
Your Honor,
you are aware of the things happening around the neighboring state?
Yes, Your Honor, what my contention
is everywhere. Yeah. Every state is the problem. But
Your Honor, the
proper court is proper, not the proper court. Proper forum is, it is the domain of the Parliament of India under the Constitution.
Your Honor, only my just nutshell of the.
No, I have understood.
Now, the state government has come to the consent. And then the withdrawal of that 17 is.
First in 2012.
Yes.
State government included you.
Yes.
Yes. Which they ought not to have done. Now they have realized in 2017. They know we don't have the power. So that has been withdrawn. So the appropriate authority is the Parliament under the Constitution.
The Constitution 1970 already clearly stated that 1970 it is already.
You are placed before the Parliament.
It is.
Parliament will consider.
So this is the contention that the legislature has taken very hasty without going through the outcome of the constituted.
Instead of coming to the court,
Your Honor,
I think, sir, you need to, this court should not say, will determine.
Yes.
Of course,
Your Honor,
your prayer, but then we are indicating.
I just like to draw the attention of the constitutional right of the state.
First you
Yeah, that is-
first you read the Article 342.
Yes, that I.
Then constitutional
I've gone
right
through,
will go to.
and they are very much. And then the 371 also very clearly say, when the state legislature, when the state authority, they agree, if they constituted, if they decide, resolve, that is become a, which can be applicable in Nagaland. Therefore, they have fulfilled all this. Therefore, there is nothing.
Court cannot
The things that the withdrawal is illegal, is violating the constitutional right of this.
No, see, state government has neither authority to delete or add. With the question of illegality. In fact, they have committed an illegality in 2012 by including.
Your Honor, regarding the.
If they feel that, if the state government feel that if it is to be, if it deserve to be added as a scheduled tribe of the state, they could have impressed parliament.
Yes, Your Honor, I just leave this in the wisdom of the court. So just for the information, the notification of 1984, any tribes, they don't lose when they migrate to any place. So the notification here.
Is it a part of the record?
Yes, no, it is only submitted. And Your Honor, at the same time, just in order
Academic.
to make a nutshell, I don't have, I will not take time, but this is my additional piece of argument. You may kindly go through and basing on that.
Additional piece of argument, or you file a written argument in that
Yeah,
case.
I'm just submitting for your knowledge.
Is it addition to or it's
Yeah, this is my argument. What I will.
okay, okay.
And then there is notification. So Your Honor may see the fairness and the constitutional right, which the citizen of India has to prevail. This is Indian, this is under the government of the government of Nagaland, I mean, government of India. So every citizen has every right to
See,
things.
This court as a individual is by heart and soul with you, that you should be a scheduled tribe of a state. But as a sitting in the chair, there is a constitutional limitation, and there is a law, as you know, which what sort of cases and what sort of issues are the whole judicial review lies. And on top of it, there's a constitutional bench judgment, which you might have gone through. Have you gone through that? 2001 constitutional judgment.
2001.
State of Maharashtra versus Milind. 2001, 1 SCC, page 4. You write it down. Where it says
Yes. Your Honor,
2001, 1 SCC, page 4.
yes.
2001,
Yes.
volume 1, just
You got it?
in view of this judgment, your petition will be dismissed.
Your Honor, maybe go through the state procedure.
I have gone
See
through.
whatever the.
That's
state-
what I'm saying.
Yes.
I'm not saying whether you are a scheduled tribe of Nagaland state or you are not. I'm not saying. This court can say also. It is the parliament. If it is to be included, it is the parliament. And if it is to be excluded or deleted, it is the parliament. And unless you are recognized by the presidential order of 1950 and the amendment from time to time, you are recognized. If it has to be added, it is to the parliament. That is the law. It's a constitutional bench judgment.
Yeah, that's the constitution says That is, which is,
The based on the constitution.
that is the whole Naga, that is, we are part of that.
No, that's what I'm saying.
That is what.
For that, this court has no authority to decide whether it includes or not includes. That is it. Precisely, I'm trying to. That's all.
Yes,
That's all.
my lord, that is what my prayer.
Huh?
That is what I pray for, that's really my.
Your prayer cannot be accepted. Is it your submission that as per the constitutional order 1950 or 1970,
Yes.
Naga tribe includes the Rangmai?
Yes,
Is your submission?
yes, this is my prayer.
From where you are submitting?
That is.
Where you are submitting?
Reflected in my petition.
Not
No.
petition. By any documents by the Act of Parliament.
Yes, that's your honor, I have reflected in my petition, sir. Yes, down to the.
Not the state government decision
No.
or the any other authority, by the
From the
Act
central
of the
government.
Parliament, any notification.
Yeah, 1950,
What is the basis of your submission?
that is only 1970.
Just show me any documents, the basis of your submission.
This 23 is that the notification that the state government.
Yes, 23.
Yeah,
Yeah, it says Naga, Kuti, Kachari, Mikir, Garo. Yes,
and then.
5 of them,
Yeah, page number 24.
24.
It is already a supplement.
Hmm.
The notification said that those who are already in this, they are very much dry and indigenous.
No, this is Joint
Your Honor-
Secretary to the Government of Nagaland.
Yeah, Your Honor, this may be only for the particulars, those who are here in, since time immemorial, since they have been in the state of Nagaland. That is the only issue. It is not only for the entire. The government, state government also already stated clear. That is only for those particular community who has no other second home, where they have died here, where they have worked here. Now, there are thousands of students, they are not getting this thing tried. And then they are not getting any government employees. This is what the whole community has suffered, not the numbers. It is only counts a handful of people. That is only 63 voters.
You satisfy this court while you are saying that the Naga includes their tribe of Rongmei, the petitioner. Show me anything on that.
Yes, Your Honor, this government has already met.
Which one?
They were enjoying. Those.
No, these are not, these are all irrelevant submission. Make a relevant submission. I'm asking again and again. On what basis you are saying that Naga tribe includes
Your Lordship,
the other tribe? Just wait. I'll come to you. Anything to show on that?
You know that is case 24 is submitted.
This is by the state government. When the state government doesn't have anything to do,
That,
has not authority to do.
So the central government parliament. That is.
You go to parliament, ask the parliament. Obviously, hopefully they'll consider.
But the parliament also depend on the subject list, so that's the issue.
The authority is the parliament, not by the state government or the court. That is the law. That's all. What is notifications talks about? this notification. Why you are in submitting this in loose?
Now, this notification is only central government notification. Though the tribe, they may migrate to any place in illegal, they are not losing the tribe. That is only the notification.
Yes. Suppose I'm a scheduled tribe of Arunachal Pradesh. If I migrated to Nagaland, I'll remain a scheduled tribe. But then I'll not get the concession, whatever benefits it gives to the tribal tribe of Nagaland. That is what it says.
Yes, Your Honor.
It's nothing to do with
Yeah, that is what now.
This is your case is for recognition as a scheduled tribe of this state. Is not it?
Yeah, Your Honor.
Which is the domain of the parliament. That is again, I'm saying.
Your Honor, I'm just saying the constitutional right. Now, the constitutional right, what means that the Nagaland state is such state. Yes, so many tribes.
You did the judgment of the Supreme Court, and they'll realize tomorrow you will come up and that will withdraw the petition.
You know, maybe just the challenging of the notification, that's what I pray for.
Okay. Yes.
Please, Your Worship,
Yes.
my affidavit in therefore,
You are for, sir.
the state respondents, Your Worship.
Okay.
May I read, Your Worship?
Affidavit by
State respondents.
supplementary.
Yes, Your Worship.
Okay.
In running page 2. Therefore,
Yes.
may I read, Your Worship?
Yes.
That in regard to the statements made in paragraph 2,
Sorry, just wait. Therefore.
therefore, running page 2, Your Worship.
Okay. Yes.
That in regard to the statements made in paragraph 2 of the writ petition, the deponent states that there are only 14 recognized Naga tribes in the state of Nagaland, namely Ao, Anganu, Sunu, Lota, Rima, Punyak, Sangtam, Hom, Chang, Yelchongo, Kemnungan, Chakasang, Ziliang, and Pujuri. The remainder is therefore not a recognized Naga tribe in the state of Nagaland. And paragraph 7, Your Worship. Your Worship. That in regard to the statements made in paragraph 5 of the writ petition, the deponent states that under the Constitution, Scheduled Tribe Order Amendment Act 2011, number 2 of 2012, dated 8/1/2012, the remainder is a scheduled tribe in the state of Manipur. However, that by itself would not mean that the remainder is also a scheduled tribe in the state of Nagaland, unless by the presidential order issued under clause 1 of the Article 342 of the Constitution of India. Your Worship, in page 20. 2.8, Your Worship. Annexure 3. Annexure 5, Your Worship. Running page 28, Annexure 5.
28.
Yes, Your Worship.
These are the list.
Yes, Your Worship. List of recognized scheduled tribes in Nagaland. May I read, Your Worship?
Yes.
Number 1, Karo, Mikir,
No, page
running page 28 of my affidavit. Your Lordship.
28.
28, Your Lordship. May I read the head note, Your Lordship?
Yes.
Government of India, Ministry of Home Affairs.
No, just wait. Page 28 or 28?
28, Your Lordship, of my annexure 5.
Annexure 5, yes.
Yes, Your Lordship. May I read, Your Lordship?
Yes.
Government of India, Ministry of Home Affairs / Kriha Mantralaya, Office of the Director of Census Operations, High School Road, Kohima, Nagaland.
Annexure 5 is something different. Yeah,
List of recognized scheduled tribes in Nagaland.
okay, on the bottom,
Yes, Your Lord, at the bottom.
yeah.
1,
Yes.
Karo. Number 2, Mikir. Number 3, Kuki. Number 4, Kachari. Number 5, Nagas. And the next page, that is running page 29, pertains to list of recognized Naga tribes in Nagaland. May I read, Your Lordship? Number 1, Ao. Number 2, Angami, Sumi, Lotha, Rima, Gunyak, Sangtam, Pom, Chang, Yinchungur, Kemangan, Chagazang, Ziliang, and Puchuri. These are the 14 recognized Naga tribes in the state of Nagaland, Your Lordship. As approved by Home Department, Government of Nagaland, right, Home Branch Letter Number such and such, dated 6 July 2009. These are the valid.
Where is this letter?
Your Lordship.
Letter dated 6 July 2009.
It is stated just below the 14 tribes of Nagaland, Your Lordship.
Okay. No. This is a note by the
Approval by the Home Ministry. Your Lordship.
Home Ministry, Government of India.
Yes, Your Lordship.
So I want this letter. Government of India, Minister, so and so, huh?
Yes, Your Lordship.
List of recognized settled tribe in Nagaland. List of recognized Naga tribes in Nagaland.
Yes.
This is 6 July 2009.
Yes.
Which is approved by Home Department, so and so.
Government of Nagaland.
No. How do you interpret this? This is by the Government of Nagaland. Where's the Government of India? Huh?
Your Lordship, just above the Ministry of Home Affairs, Government of Nagaland, Department of Personal and Administrative Reforms, Administrative Reforms Branch. Letter number such and such, dated Kohima, the 1st June 2009. Office Memorandum. Subject: clarification on issue of backward tribes certificate.
It's okay. This is by you only, by your government only.
Yes, sir.
Home Department.
Yes,
and the
PNR.
Department PNR.
Yes, sir.
I want the notification of the Government of India, presidential order.
So far, Your Lordship.
One presidential order, the petitioner annexes page 23 of the writ petition. Thereafter, there must be something more than that. It only recognizes 5 tribes. Naga, Kuki, Kachari, Mikir, Garo.
Yes, Your Lordship. That is for scheduled tribes.
Ah.
And for the Nagas, the next page, that is running page 29, Your Lordship. That is the list of recognized Naga tribes in Nagaland.
By whom?
by the PNR.
Not PNR. When you don't have anything to say, you may clarify as per the presidential order. When you don't have anything, I mean, power to delete or add or delete, how you can just give like that? Where it is recognized, all the 16 tribes, apart from your letter, state government letter.
In general, NACAS that is approved by the Ministry of Commerce. In general, that is running page 28. It says about the these are recognized scheduled tribes in Nagaland. That is.
No, I'm saying this is by you. Where is the recognition by under the presidential order of 1950 or thereafter? By the central government, presidential notification.
That we have not.
Where is that is important?
Yes.
Unless you don't have an authority to decide or add or deletion, how we can accept this preparation by your department?
Prior to the statehood of Nagaland.
See, what he said is, of course, he is not able to substantiate by documents. The Nagas are recognized as a scheduled tribe under the presidential order, page 23.
Yes.
Naga includes the Rangmai, apart from these 14 other tribes. So by your showing by your government, you say these are the 14 tribe of Nagaland. So Rangmai is not there.
No. If
And Rangmai has been added as a scheduled tribe of the Manipur.
Yes.
Your presidential order only says the Naga. It doesn't prescribe other tribe.
Naga includes only 14 tribes.
Yes. From where?
Prior to the statehood of Nagaland, way back on 1st December 1963, those 14 tribes were the permanent settler of the Nagaland.
Yes. So show me they recognized by the. I know the history. You may say he has also tried to say something.
If I may be allowed to read out some of my statements, that is starts from paragraph 8, Your Lordship, of running page 2 of my affidavit, Your Lordship. So as to make the position clear. May I read, Your Lordship? My affidavit, running page 2, paragraph 8, Your Lordship.
No, that's I've seen it. I agree to that. These are only 14 tribes. Naga 14 tribes. 14 tribes.
Yes.
Correct.
Yes.
What is the recognition apart from this state government letter or the statement?
So far,
there is nothing.
but if I may be allowed to read paragraph 8, Your Lordship.
According to you, as per the presidential order, Naga includes only this 14 tribes.
That's the
Not more than that.
not more than that.
So how do we know that this is it's as per the constitutional order?
Since
Fact may be correct, you may be correct in fact, but it has to be declared by the parliament.
Nagas were
from time immemorial. You are from the same.
Do you agree? Any addition, deletion is to be by the Parliament of Act of the Parliament under 342.
Yes.
So what is that? That is what I'm trying to tell you.
If I may be allowed to read. para 8.
No, I have understood. It's okay. Before we read, before we say, we'll have to consider.
We are not denying them, Your Lordship. 1,300 churches.
Yes, that is something.
Roommate
That is
community.
another issue.
Yes, Your Lordship. But they don't have landed property. They migrated. They settled down in the state of President Nagaland.
It is not the court to decide
Yes, Your Lordship.
whether they are a scheduled tribe or not. As I said, not you, not the state government. It is the parliament.
Yes, Your Lordship.
So you can you show me that as per the presidential order, Naga includes these 14 tribes only, not the petitioner. Can you show me anything on that? You don't have.
No.
You don't have. So you just
We remain as
your
Nagas.
submission is that Nagas are
14
only
tribes.
14 tribes.
Yes, sir.
Not more than
No.
nothing more, nothing less.
No.
That is your submission.
Yes, ma'am.
But this court wants that there is something, anything in the presidential order which mentioned this.
No.
It only says Nagas.
Nagas.
It's a gray area. Though, of course, neither the government nor the court has the power to say, declare that these are the scheduled tribe is not the scheduled tribe of the state. But then, academically, when you take it,
Yes.
he's also correct. If he's settled here, for example, Nagas could be into so many other tribes also. Unless you show that this has been recognized constitutionally, is not it?
Yes, Your Lordship. But then,
So that is not the issue. Issue is here, main issue is, larger issue is, the question is whether this court can decide whether the petitioners are the scheduled tribe of the state or not. That is the main issue. So you are showing the presidential order of 5 tribes. And you are saying that by the state government, and effectually, only these 14 tribes are the Naga tribes, which is recognized
yes,
under the constitution.
yes, sir.
But there's nothing to show that these are the only 14 tribes, which means the Nagas recognized in the constitution. There's nothing to show, except the state government
Yes.
clarification,
Yes, sir.
not the central government notification. Correct?
Hmm.
Maybe it's just a gray area, you may say so, but then ultimately, for the purpose of this petition, court doesn't have the power and authority, nor you, the state. If it is to be added or deleted by the parliament, that's all.
But Your Lordship here, to make my position very clear, because of the stakeholders in the state of Nagaland, it is shown as 14 tribes, whereas roommates, who are the stakeholder in Manipur, your tribes were recognized in the state of Manipur. So also, Nagas of other states who does not have their landed property in the state of present Nagaland, they cannot claim for scheduled tribe in the state of Nagaland. That is the issue. That is our standing.
No,
And for the Nagas, which comprises of 14 tribes, they have their ancestral land, they have their landed property, they have their cultivable land to establish their villages. That is how they are recognized as 14 tribes of Nagaland. That's all. And for the roommates, they were migrated as a laborer. And my learned friend has clearly pinpointed.
what is it?
My learned friend has pinpointed that they've come. And
No, before that, what you have said?
my lord,
Before that, what you have said? Just before that, what you have said?
they came here as a laborer.
Don't use this word. It is not permitted by this day and age.
Even otherwise, they are
Use
not
the, use the,
conferred
use
the tribe.
the, use the more appropriate word.
Okay, Your Lordship.
It is not permissible, at least before this court. You just cannot use this word.
Even though they are not recognized and conferred the status of scheduled tribe, they are given indigenous inhabitants of Nagaland, whereby they are getting all the job opportunities
In the district of Parent.
in the state of Nagaland.
In the state of Nagaland, instead of the state, particular district of Parent.
Here, my lord, if I may be allowed to read para 8 of
Yes.
my running page 2 of my affidavit.
Yes.
That in regard to the statements made in para 6 to 12 of the writ petition, the deponent states that the amendments made by the petitioner in the said paragraphs are not relevant for adjudicating the present writ petition. The deponent states that it is only the person from the Rungme community, numbering 1,313, who has settled in the state of Nagaland prior to 1st December 1963, and whose names finds mention in the enumeration of members of the Rungme community under Parent district, are entitled to enjoy the status, privileges, and entitlements of indigenous inhabitants of Nagaland, similar to the ones enjoyed by the members of the other indigenous inhabitants who have permanently settled in the present territory of Nagaland prior to 1st December 1963, as notified by the state government, white notification number such and such, dated 6/7/1973, and number such and such, dated 28/4/1997. Minus the enumerated Rumes, the race members of the community has no right to claim the indigenous inhabitant of the state of Nagaland.
So what about the fate of this offspring of the 1313?
They can still enjoy. Similar to the tribes of other state, other tribes of the land. They are enjoying for job opportunity.
So you have to mention this numbering 1313.
Yes, Your Lordship.
Including
Don't
the,
deprive-
including the descendants and the offspring of
Yes, Your
this 1313.
Yes, Your Lordship. Your
Without
descendants.
saying so, by 1963, if you calculate this 131 with greatest respect, they might, maximum might not be alive now. So it should include the offspring and the
That is included, Your Lordship.
descendants of the 1313. Correct?
Yes. Your Lordship. And I may be allowed to read para 11 also, Your Lordship, of my affidavit.
Yes.
That in regard to the statements made in para 26 to 31 of the writ petition, the deponent states that subsequent to the issuance of the notification dated 4/8/2012, recognizing Rungme as one of the Naga tribe, and for the issuance of the scheduled tribe certificate and indigenous tribe certificate to the members of the Rungme tribes who or whose ancestors were enumerated in 1963 electoral roll of the state and whose names were enumerated in the report dated 31/5/2012 of the committee set up by the government to examine the issue of granting the status of indigenous of Naga tribe to the members of the Rungme community. There was vociferous objection from various tribal hosts and indigenous community of the state. The objection raised by different groups was examined by the Home Department, and a cabinet memorandum number such and such dated 10/9/2013 was prepared to review the cabinet decision dated 23/7/2012, granting the status of indigenous Naga tribe to the members of Rungme community. The cabinet examined the matter and constituted a committee to study the
It's okay,
issue.
sir. I've read it. I've read it.
Yes, Your Lordship.
Make a submission. If anything.
In support of my contention, I have few citations, Your Lordship.
which I have supplied. May I read, my lord? What are these if a violation of fundamental rights is not shown, court will have no occasion to interfere with a policy decision by way of judicial review. 2005, clause 13 SSC for 495. There are 5, 6, 7, and 8. Just wait. He has submitted he has not submitted any books. Huh? Have given.
Not just in this. On the paper, but
on.
just.
Oh.
He didn't submit it.
Have you submitted a list of books?
Yes. Sir. Just like this.
Yeah.
Like this is submitted.
Just say 2005, clause 13 SSC 495. There are 5, 6, 7, and 8 members. I've supplied the query. You just keep it like this. 13 for us. Yes, it's okay. Then I don't have to. Yes. Number 2, 2008, clause 5, SSC 550. Hand note, there are 13. Why hand note? Why head note? Do you want to read? Yes, you will. According to it's a policy decision. Is it a policy decision? Recognizing, not recognizing a particular tribe as a scheduled tribe of the state. It's not a policy decision. It's a constitutional mandate by the parliament. Rightly or wrongly, with or without application of mine, the respondent authorities had exercised. And later on, we were found to be in the wrong track. That was how it was de-recognized. That's the convention. Politician, to the extent of granting them, giving them benefits of some benefits. Yes. But recognizing, you just cannot say that you are not a tribe. As a state government by a policy decision, you cannot say that this is not the scheduled tribe of this state or not is the scheduled tribe of this state, because you don't have the authority. You can maintain what has been recognized. I understand every state does have a problem. A state like Arunachal Pradesh also having the same problem. Because all of us were together at one point of time under the as Assam, known as Assam. Your Lordship, I solely rely on 2001, one Supreme Court cases. So, which was given by your Lordship. Yes, paragraph. I have not seen the paragraph. My lord. Running page 5, small f, your lordship. Just show me,
Paragraph, what is the paragraph?
Head note,
No, come to the body of the judgment, head note, it's not,
paragraph 36,
yes.
page 30, Your Lordship. Paragraph 36, page 30, Your Lordship. May I read, Your Lordship? In the light of what is stated above, the following positions emerge. One, it is not at all permissible to hold an inquiry or let in any evidence to decide or declare that any tribe or tribal community or part of or group within any tribe or tribal community is included in general name, even though it is not specifically mentioned in the entry concerned in the Constitution, Scheduled Tribes Order 1950. Two, the Scheduled Tribes Order must be read as it is. It is not even permissible to say that a tribe, sub-tribe, part of or group of any tribe or tribal community is synonymous to the one mentioned in the Scheduled Tribe Order if they are not so specifically mentioned in it.
See, I want you to read this. Paragraph 36. You might have come across. Are you purposefully not placing this judgment?
Yes. My lord, the
No, let him complete. Let him complete. That's all.
And three, Your Lordship. In my citation,
Yes.
that is violation of executive guidelines and instructions, Your Lordship. I've given AIR 1967, SC 1753, Clause 3J, Para 11 and 12. Number two, AIR 1958, Supreme Court 398.
We'll consider what is relevant. Whatever you give, we will not consider. It's more than enough.
Okay.
All right.
Yes, sir. And last but not least, I want to conclude my submission.
Yes. Yes.
In paragraph 14 of my affidavit, Your Lordship, if I may be allowed to read, that in regard to the statement made in paragraph 34 of the writ petition, the deponent states that the decision taken by the state cabinet on 25/4/2017 was finalized only after minutely examining the objections raised by the various tribal organizations of the state and keeping in view the larger interest of the state. The deponent further states that as all the committees constituted by the OM dated 24/2/2014 and 27/9/2016 to examine and recommend the status of indigenous Naga tribes to the members of Rome community did not submit its report to the cabinet for a decision. And in view of the importance of the matter having a pressing demand, the cabinet took the decision on 25/4/2017 to withdraw recognition of Rome tribe as one of the indigenous Naga tribes of Nagaland. The deponent states that even with or without the report / recommendation of the committee, the state
Cabinet is not handicapped to take a decision on the matter, provided it is not arbitrary and unreasonable.
Okay.
And last, para 19, Your Lordship. That the deponent states that the instant writ petition is devoid of merit and
It's
the
okay, it's
petitioners
okay.
have failed.
It's okay. That's all.
Much obliged.
With respond number 5. Respond number 4, non appears. Huh?
Number 5, Lordship.
Who are you?
Lordship, I'm one the person who is hailing from the Rongmai tribe and settled in Nagaland prior to 1963.
You have not filed the affidavit.
I filed an affidavit, Lordship.
Okay. Yes.
Lordship, the Lordship may come to my paragraph 8, page 3.
You have been made a party or you have included yourself?
Lordship, I've filed an intervener in it is on 5.
Eight.
There are 8, page 3.
Yes, read it. Huh?
Yes, Lordship, I may be elaborate. That the statements made in the paragraph of the writ petition is no comment from the mentioned point. However, the deponent hails from Rongmai tribe and settled in Nagaland prior to 1963, and there are 1,313 persons from Rongmai tribe. Those who settled in Nagaland prior to 1963, by virtue of which they are enjoying the indigenous status in the state of Nagaland. Therefore, the indigenous status of this 1,313 persons and their families, which includes their successors, should not be disturbed, and their rights and status in the state of Nagaland be maintained by the government in the interest of justice and fairness. That's my submission.
You are not claiming as such that I am a scheduled tribe of Nagaland. You said I am a
No, Lordship,
tribe.
but since I hail from the Rongmai tribe and I have been settled prior to the formation of the
You want
Nagaland.
just the benefits which they have extended. This should
No,
not be stopped.
Lordship.
That's all.
Lordship.
You are not claiming that they should be recognized as a scheduled tribe.
No, Lord.
As like that of
No,
unlike the petitioner.
no, Lord.
Okay. That's all. Heard, Mr.
Yes. My lord, before
You have to reply something.
before dismissing, I just want to remind one very urgent issue.
No, I'm not passing the order to
Yes,
you.
the
It is,
issue.
I'll keep it, I'll reserve the judgment.
Your Honor, meantime, I just want to remind one issue. Now, those people.
You want to submit or you want to
I
remind?
just want to add it to my hearing that the status of those 1313, they are not getting any documentation. Though the state government is not denying to issue in this list, still then the head of department are not issuing. This is one issue that the state.
It's okay, part 2 of your impute order,
Yes.
second part.
Yes.
It says they'll
Now,
provide the benefits.
yeah, now the issue.
1313.
Yes, that should be issue for the benefit of the students who are coming, they're suicidal in their career. So this is very urgent issue that may be considered. And then.
No, I'm not getting it.
No, still, those indigenous
1313.
though government.
You are
is
not getting the benefit.
Yeah, not withdrawing. They are only take of the Naga tribe. Still then they are not issuing the indigenous. So this is help for the students.
That is not the issue, because part 2 of the, impute order, they said they'll continue to provide the whatever entitlements they have as that of indigenous Naga tribe. Yes, accordingly you approach.
Yes, Your Honor, I personally approached to the Deputy Commissioner Dimapur for my family.
And then we say that there is nothing written from home, still then I'm not issuing.
So in that,
Therefore,
so
we are-
in that case, you file a separate writ petition.
yeah, that is what the
Not, we will not be able to decide
so
in this.
the state also may be considered. Of course, the state of Nagaland, they have
Yes,
considered.
state,
Yes.
consider, you have said you will provide
Right.
benefits.
Yes. Please, that will be relief at least. Now the issue may be dragging for many years, I don't know, but the student like.
You are the one who has dragged this matter.
Yeah.
That's why today also you want to,
You know, this is the issue of the other party, implead and adjournment. So my senior principal counsel came for several times. Whenever he come up in lakh of rupees we spend.
see, it's,
So we have a-
it's a, I would call it a procedural hazards.
Yes,
It may apply to you also in some other matter. It's goes on.
yes.
It's a
that's-
part of the profession as it's a procedural thing. So you cannot help it out.
It's your lordship may be just kind enough to relieve the agreed citizens. who are suffering. Lordship may be considered the issuing of this issue also, this indigenous, particular to the indigenous certificate.
No,
Your
that
lordship-
that is not the subject matter here. That's not the subject matter here. You approach the approved authority, if not. You may file, if it is, you can show that it is maintainable, you can file an appropriate application
Maybe
for
just-
consideration. We'll consider what is to be, what is required to be considered in this petition, not beyond that. All right?
Yes.
As I said, this court is with you as an individual by heart and soul,
Lordship,
but we'll have to decide in accordance with the law
Lordship,
and the constitutional mandate.
Your Honor,
Correct?
thanks very much.
Heard, Mr.
Kamai Alin Ramai.
Learned counsel for the petitioner, and also heard
Sipung say something.
Sipung says.
learned additional AG.
Yes,
Learned additional AG.
assisted by with to
And
Second.
Posiko Pote for respond number 5. None appears for respond number 4. Hearing concluded. Judgment reserved.
Lordship, I'm sorry.